the inaugural, the beginning of our Judiciary Mediation Week. And then after, we'll have a break. We'll come back with a panel discussion, and then we'll definitely proceed with different presentations, especially from Mr. Bruce and the rest that will be speaking. So without further ado, my Lord the Chief Justice, I would like to introduce how the flow of this program is going to be. In the few moments, we'll be having remarks from the President of the Bar Association, Maitre Moise. After that, we'll have remarks from the chairperson of the Court Mediation Advisory Committee, Chief Justice Emeritus, and lastly we'll have the keynote speech from the guest of honor, who's the Honorable the Chief Justice. We'll break off for a very short break and then have a photo session. Then we'll come back with our panel discussion. So without further ado, I'll request the President of the Bar Association to proceed and come and give his remark. Thank you so much.
Honorable Chief Justice, Honorable Chief Justice Emeritus, Bruce Edward, the founder of Edwards Mediation Academy, dear participants, all protocols observed, good morning. It gives me a great pleasure to join you all as we launch the Mediation Week. Rwanda Bar Association was very pleased to partner with the judiciary in organizing this Mediation Week. The purpose of the Mediation Week is to raise awareness among the public and court users, especially lawyers, about the benefits of using mediation in resolving disputes. At the end of the day, during this day, you're going to be discussing mediation. But then what does mediation mean? Mediation, as one of the alternative dispute resolution mechanisms, it's a process in which a third party that is supposed to be impartial, that has no stake in the outcome of the dispute, and has no power to impose a decision, guides disputants through a non-adversarial discussion process that has as its goal the settling of the dispute between or among the parties. It's therefore an effort to put the parties in an indirect contact, gain trust and confidence in each other, to set an agenda and clarify issues, and then at the end of the day, this happens when they've arranged a venue in which they're going to be meeting. Reducing the tension is also one of the criteria that happens parties to resolve their dispute. Exploring interests of the parties is also very important when you're going through such a process. As you might be aware, of recent, the government of Rwanda adopted the alternative dispute resolution policy. This development came to reinforce the initiative of the judiciary of putting in place and encouraging court-annexed mediation. In our jurisdiction, the use of mediation as a dispute resolution mechanism by professionals, I would say that it's pretty much new. We are therefore still at the stage where we are supposed to be raising awareness and build the capacity of these professionals to make sure that mediation becomes part and parcel of our jurisdiction dispute resolution mechanism. It's against this background that we still see some of the lawyers in mediation resisting Therefore, such a training is an opportunity to encourage lawyers here present to embrace mediation and provide a quick solution to the matters, and this should be allowing them to conclude the matters and then even get to be paid their lawyers' fees. Lawyers also play a very key role in mediation. They might be playing a role as a legal counsel, or they can even play a role as mediators. All these functions require skills, an understanding of high level of emotional intelligence of the parties, and this allows the professional to bring together the parties that are involved in a dispute and then be able to provide a quick solution to the issues. The function of justice is to promote a peaceful society by fighting impunity and giving each party its due in due time. As per the saying, justice delayed is justice denied. It's therefore important to mention that mediation offers a good number of advantages over litigation. Litigation as a traditional way of resolving dispute has shown that when a case is concluded, there are always a winner and a loser. This scenario leaves unresolved issues that can actually create mere disputes rather than resolving issues and dispute among the parties. I can give an example. If you see, like, for instance, there's a number of judgments that are rendered by courts of law, and then when it gets to the enforcement, issues are arising because parties do not understand in the same way the judgment that was rendered by the courts. The same also happens to the future relationship of the parties. The future relationship of the parties when they are out of a litigation are completely broken. It's therefore important that we also consider this, especially for people that are in business. Having an understanding that resolves the dispute and leaving the relationship among the parties surviving is very important, and we should consider this as we help people to go through this process of mediation. Another advantage is the fact that litigation happens in public. Not every party to the dispute wants his or her issues to be exposed to the public. We've got companies that are listed. Not exposing their matters in public allows them to keep it in secrecy, and this allows mediation to be the one to consider over litigation, because it allows the parties to, like these listed companies, to keep their secrets, and then people should keep having faith in what they do and their business. Another thing is that mediation is also time effective. The reason is nowadays you might have a litigation that lasts for 5 years. But when you're going through mediation, you can limit the time in as much as you can, and this allows you to resolve the matter as quick as possible. Another advantage over litigation that mediation has is flexibility. You might not necessarily be going to have a judge that is specialized in the matter that you have as parties, but at the end of the day, you might decide the one that is going to help you in mediation as a specialized person, and also who is going to be flexible. Mediation is completely different from a court setup where you're supposed to be following the rules of procedure set by the law, which are not necessarily going to be helping in resolving your dispute. As I mentioned above, mediation is a mechanism used in resolving disputes. That being said, lawyers play a very important role in the same process. It is to be mentioned that lawyers who are involved in mediation should be paid. Why am I saying this? The reason is nowadays we are facing an issue of lawyers not embracing this whole mediation process, because sometimes the parties fail to get an understanding on the legal fees. Yet, legal fees is part and parcel of disputes. And whenever anyone is involved in the mediation process, he or she should be paid, either as a mediator or a legal counsel. But then, this should not be the only one aspect of not concluding matters that are referred to us as mediators or as legal counsels. When you look at the regulation fixing the scales of advocate fees in its Article 22.2 and 3, it provides a good number of ranges that allows a lawyer to have flexibility in terms of determining his or her fees. Lawyers should therefore look at mediation as an opportunity for both resolving disputes and also doing their business and improving their livelihoods. Mediation can help a lawyer to quickly solve a client matter and get paid instead of waiting for litigation for 5 years. I did mention this, and this helps us to build the reputation. If you're going to be known as a lawyer that provides solution to the client and then get the matter resolved as quick as possible, then it gives you an opportunity for more business. It's therefore important that we consider this alternative dispute resolution mechanism as an opportunity for us, instead of looking at it as something that is going to undermine our business. In conclusion, the role of an advocate in mediation is paramount in solving disputes, and this can build his reputation in providing quick solutions to the matters referred to him. I therefore encourage all participants to embrace mediation and consider the same as a way to go. The reason being that we have seen that litigation is not helping in solving all the matters that are prevailing in courts of law. Let me conclude my remarks, Honorable Chief Justice, by saying that we are very happy to partner with the judiciary to continue working on this, because we've seen that mediation is one of the ADR that is going to help reducing the court backlog and also helping lawyers to get what they are supposed to be getting at the end of the process in due time. I therefore want to also encourage the members of the Bar Association here present, the advocates that are here, to make good use of this day and have a participatory session that is going to help them in improving their mediation skills going forward. I thank you.
Thank you very much, the President of the Bar Association, on the very deep presentation and speech on the role of lawyers in mediation. And thank you very much for partnering with the judiciary, especially to make this day a success. Without further ado, I'll invite the chairperson of the Court Mediation Advisory Committee, Honorable Chief Justice Emeritus, for your remarks. Thank you very much.
Honorable Chief Justice, Mr. and Mrs. Edwards, welcome back to Rwanda. Batonier, my learned colleagues, ladies and gentlemen. I'm glad to be here, taken out of my retirement to come and talk to illustrious lawyers, but also to meet my friend Bruce. It is an important occasion important to us, especially in my committee. As you heard, I'm here representing the Court Annexed Mediation Advisory Committee, which was set up by the Honorable Chief Justice to monitor the workings and the activities of court mediations or court-referred mediations, and to make sure that those who are appointed as the mediators or who are given cases to mediate are people of integrity and command the confidence of members of the public. That committee is composed of stakeholders in the justice sector, including the judiciary, of course, the Bar Association, the Legal Aid Forum, KIAC, and the private sector federation. I hope I haven't forgotten anybody, but this event is a part of our activities. We were involved in organizing it when Bruce Edwards communicated that he was coming to Rwanda. We were anxious that he should be able to meet a number of groups so that they can all benefit from his experience and wisdom. So, I will not talk about the benefits of mediation. I'm sure you've heard me talk about it many times. And Batoni has just talked about them. And Bruce will be talking about some of those benefits. So I just want to talk about the situation here relating to lawyers and court-connected mediation. My understanding is that lawyers in mediation are there to advise, to guide, and to negotiate on behalf of their clients, to assist them during the process of mediation, and also when it comes to drafting an agreement, to assist them to that effect. And in my experience, that is being done. Most of you are trained mediators or have done the course in mediation skills or have done the course in mediation advocacy. And a lot of the mediations that are taking place are actually done by practicing lawyers. And what I found, others are also, of course, coming with their clients to assist them in mediations. Many of them have expressed satisfaction at this experience with the mediation and would like to do more of it, which is very encouraging. My personal experience as a mediator is that I am impressed with the performance of our lawyers during mediations. They are very respectful. They assist their clients, try to get the best deal from the discussions, but also aware that the need to reach an agreement which is acceptable to both sides as far as that is possible, which might include having to compromise on some issues which were being litigated. I find that there are maybe two types of lawyers I've seen advocates in mediation. There are those who are a bit combative or who still have perspective of litigation and try to drive a hard bargain in the negotiations. On the other hand, there are others who are more passive and who kind of sit back and listen and only intervene when they are asked their opinion or when they need to caucus with the clients. So there are those who prefer to do the talking behind the scenes. But on the whole, I think it is satisfactory. I was asked to say something about my discussions with judges and the registrars, because as a committee, especially the bureau of the committee, which consists of the chairperson, the vice chairperson, who is Justice Karimunda, Bernadette as the secretary, and Inspector Harrison as spokesperson of the judiciary. We've been visiting courts over the last few months. We've visited at least 9 courts within the city of Kigali and the bigger towns. And the program continues. What we've heard about the interaction with lawyers is that they are mostly not enthusiastic. Many are reluctant to go into mediation or to persuade their clients to participate in mediation. There are those who actively discourage their clients from participating in mediation. We had a story, I think, from Gasabo Intermediate Court, where the lawyer and his client, before the court, agreed to go and try mediation. But as they were going out of the court, by the registrar's window, the registrar overheard the lawyer telling his client, "Forget about that mediation business. We shall win our case." So, of course, they didn't go to the mediation. But that lawyer was later called and told that what he was doing was not to be expected of a lawyer. It was not respectable. Anyway, as I say, we have many lawyers who are cooperative, who are enthusiastic about mediation. I'm sure most of you are in that category, but there are others who are still resisting for different reasons. I wouldn't say I know why they in particular resist to go into mediation, but maybe Bruce will have something to tell us about that of his experience, but I know it is not unique to Rwanda, and perhaps that's encouraging to know that conversion to mediation is a process, it's a long-term process, and that we should not be discouraged. We should hope that progressively more and more lawyers will join this movement of peaceful resolution of disputes. There are, of course, those who are convinced that that is the way to go, who know that their training is in litigation. They know that from their perspective, justice is done when two parties go before a judge, tell their story, and he, the judge, who is trained to take decisions, decides what is just. So they do not believe in these mediators who have nothing to show that they are adjudicators to take decisions. So there are others who say, well, litigation or lawyering is a business, and we have to find the best means of making our business successful. Don't tell us about fairness and all that. So obviously they have their reasons. There are also those who think mediation, since it is a matter that ends the dispute once and for all, it is likely to cut on the earnings of the lawyer, because the matter will not continue in different courts. It is finished once and for all. There are no reviews, there are no nothing. And also, even at the stage of the first instance, they might worry that they will not get all their fees if the matter is concluded with the mediator within a few hours. And he had indicated that the trial will take so many weeks or so on, and therefore he might have to negotiate a cut in his fee. However, as the bâtonnier has said, the lawyer must be paid for what he contracted for. There should be no question of losing your earnings. Maybe if you were using the method of calculating your fees according to time, then that could be adjusted once a matter is completed during mediation. But I guess again we have to learn from others how they are doing it. So, what is the future? What do we hope will happen? We hope that with continuing training, with our colleague Bernadette churning out more mediators every 3 months, we'll have a lot of mediators from among the profession. We'll have a lot of mediation advocates, and therefore we'll be having a lot of ambassadors to go and tell their colleagues how good mediation is, how you don't lose your earnings because you've gone into mediation, how it brings about more peaceful coexistence among the members of the public, and so on. The numbers are still low. We have like 800 cases mediated a year, but that is out of about 70,000 cases that are in court to be adjudicated. So the numbers are still low, but we hope they'll increase. Yeah. And then, of course, there is the ADR policy, which, as you know, was passed last September. And in that policy, there are recommendations. One of the recommendations is that there should be court-ordered mediations, so that if a judge decides that on the facts this is an appropriate case for referring to mediation, he has the power to order that it goes to mediation, which is different now, because here now it depends on the persuasive powers or persuasive skills of the judge or the registrar to persuade the client, the litigants, to go into mediation. So court-ordered mediation is working very well in Kenya and in some other countries. There is no reason why it wouldn't work here. And the other proposal is that there should be pre-filing mediation, so that before any case is filed into court, is accepted by the court, they must try mediation, just like is the case with the lower cases with Abunzi. This time it will be even higher cases of high value. This might be done in phases, especially in commercial matters and family matters. And then progressively more can be introduced as more mediators become available and as more people get used to the system. This introduction of pre-filing mediation and court-ordered mediation, I think will be a good strategy for exposing mediation to more people lawyers will be obliged to participate, and they will get used to it, and they, I think in the process they might be converted to see mediation as a mainstream form of resolving disputes. It will also be an opportunity for members of the public who experience mediation to tell their family and friends about mediation, and therefore get rid of the litigious mindset. Having said all that, the problem is not just with lawyers, or some lawyers, but it also is with the members of the public and even court officers. There is a reluctance of litigants themselves, as I said, because of their litigious mindset that has been developed over the decades since we got rid of our traditional gacaca and traditional other ways of resolving disputes through colonial imposition. There has developed this litigious mindset. So people are still believing in courts. They don't have trust in other forms of dispute resolution, or it is because they feel that they must show the other party that they are right, that everybody might know that that dispute was caused by the other party and he must pay for it. They must make him pay for it through the courts. So all that has to change through awareness raising, and part of our mandate in the committee has been awareness raising among the public, giving interviews and media talks, media shows, having role plays during public meetings. All this is part of the awareness raising to make the people aware and to get to like mediation. As I said, there is also a problem with our court staff who are not trained either in mediation or in the skills of persuading litigants to opt for mediation rather than litigation. In our visits to the courts, we talked with registrars and with judges, and you could see that they were unsure of what they were supposed to do. At the end of 2 hours, you could see they were more enthusiastic about mediation and promised to do more of it and to try and persuade. They now know how to talk to litigants to get them to accept mediation. So there is need for that continuous training and conversations with the court staff. Yeah, and overall we are optimistic because we have the support of the Bar Association. Batonier is a member of our committee and is very supportive. The previous president of the Bar Association, Mr. Kavaruganda, is also very enthusiastic. So we hope that we shall continue to have cooperation of the bar to push forward the agenda for mediation and ADR in general. And of course, we are lucky this week to have Bruce Edwards here with us, addressing different groups. You are the first ones. Bruce, I think he will be more formally introduced later, but I can't resist saying a little bit about him. He's a highly experienced mediator and arbitrator, founder of the largest ADR organization, I think, in the world, JAMS. Is also a founder and chief executive of the Edwards Mediation Academy. And of course, Susan there is he's the chief operating officer for the cause. Yeah. Bruce has done thousands of mediations over several decades. And these are not just small cases, these are cases involving millions of dollars. These are cases that involved multiple parties, especially in construction business, in insurance, personal injury, torts, employment, and so on. Yeah. So he abandoned his litigation career when he was still a young man to go into mediation, when mediation was only starting in the United States. So I'm sure he is the best person to talk to lawyers and show them how to transit to move from being a litigation lawyer to being a mediation advocate, or to being a mediator. To show you the pitfalls, the trials, the challenges, and how to overcome them. So we are really very happy to have him here today to talk to you. A similar workshop like this was done in Zambia for lawyers 2 years ago and was very successful. Zambia started their programs like we are doing now, or put them into legislation more than 10 years ago, I think around 2010, but it didn't take off, largely because of resistance from the lawyers. The legislation was rendered useless. But after the training of lawyers and explaining to them the benefits of mediation and how they can go about it and yet maintain a successful career as lawyers, the mediation is now picking up in Zambia, as we hear from some Zambians, both at the judiciary and at the bar. We met them last year at a conference in San Francisco. Yeah, so that's why we insisted that when Bruce comes, he has an opportunity to be able to talk to you, and I'm sure you'll enjoy and benefit from his discussions with you today. Thank you, Mr. Chief Justice. Thank you all for your attention.
I'd like to thank Honorable Chief Justice Emeritus for this profound speech that has taken us through a lot, and we'd like to thank him very much for all that he's doing to spearhead the court-connected mediation at all. We're transitioning probably to the end of our last segment, and at this juncture, we're going to invite the guest of honor, the Honorable Chief Justice, to give us his remarks. Honorable Chief Justice, please. Thank you so much.
Thank you very much, Justice Harrison. The Chief Justice Emeritus, Honorable Professor Sam Lujeje, honorable judges and other judicial officers here present, the President of the Bar Association, dear Bruce and Susan Edwards, member of Court's Annex Mediation Advisory Committee, senior advocates, distinguished guests, ladies and gentlemen. It is really a great pleasure. It is a great pleasure to be with you this morning, especially to have in this August audience the Chief Justice Emeritus, our friends Bruce and Susan, but also you all member of this August audience. It is very, very good that we are talking about this matter, and that especially due to the help of the Court Annex Mediation Committee, this event, the first of its kind in the history of the Rwanda judiciary, is convened together, and where we'll be sharing knowledge on the enhancement of mediation in the court. As I said before I go further, I want really to thank the Court Mediation Advisory Committee and different stakeholders. Starting with the Court Mediation Advisory Committee, it is a privilege. It is a privilege for me as a Chief Justice to have the Chief Justice Emeritus and the wisdom that he has just shared with you, but also to have him accepting to chair the Court Annex Mediation Committee. It is not, we are not taking it for granted. We are very appreciative, and really we thank the Chief Justice Emeritus, but also the Court Mediation Advisory Committee for the tremendous job they are putting in sensitizing people, in accompanying the judiciary in the administration of justice. We are really most grateful. I would like also at this juncture to thank all stakeholders. The Rwanda Bar Association, it is really very important to hear from the president of the Rwanda Bar Association, and especially expressing the support to this initiative. We have other partners like the Legal Aid Forum, Transparency International Rwanda, who are every time teaming up with us in this exercise, but also in the other area aspect of administration of justice. I said that we are very appreciative of the support we are getting from the Edward Mediation Academy, Bruce and Susan Edwards. Just when we were entering this room,
Bruce Edward was telling me that, I was telling him that I saw him in India, and he said, okay, yeah, I am coming from the Middle East, from Egypt, and he was saying also that Susan is starting to conduct a mediation, training for Ukraine, across the world. You see, distinguished participants, we are very, very privileged to have them with us, because those are the people we want to have with them, so that, as the Chief Justice Emeritus just said, we can learn from their vast experience. And I am sure you will be convinced afterward that doing or practicing mediation is not a pro bono exercise. It is a business. It is a lucrative business. So I am sure that you will hear from them. I am not here to talk about what will be. I can't even do it. But I am confident that we will go from here very excited and looking to the very opportunities that mediation is bringing in to the administration of justice. The Mediation Week, among other, is geared at raising great awareness among the public and the court users about the benefits of using mediation in resolving disputes and its availability as a prior filing option. As it was been mentioned, historically, Rwanda culture has always favored an approach focusing on the preservation of relationship and coexistence. And these mediatory processes has been in place way before the coming of classical courts. For instance, during the post-1994 genocide against the Tutsi, Rwanda successfully used restorative justice approach through Gacaca courts to deal with the huge case backlog in genocide cases and to rebuild the social fabric. We know also the contribution of the Abunzi system, which is equally revolutionary from the global perspective that it is a form of mandatory prefiling mediation for a large class of civil matters that would otherwise be filed in courts in the first instance. It is in this regard the judiciary of Rwanda, after the amendment of the 2018 civil procedure, embraced the court-annexed mediation system, which was endorsed by the alternative dispute resolution policy, as it was mentioned, that has been adopted by the government of Rwanda as one of existing initiatives built on in expanding and enhancing the use of mediation in a dispute resolution. I'm again grateful to the Chief Justice Emeritus for just highlighting the recommendation of the ADR policy in terms of enhancing the practice of mediation in our country. With regard to the court-annexed mediation exercise practice, as one judge pointed out, mediating disputes that have already been brought before court, done with the encouragement and ultimately the supervision of courts, carries the benefit that parties knowing and understanding their rights may nonetheless find it in their interest to resolve the dispute without pursuing the right to the bitter end. End of quote. In addition to the well-known benefits of mediation, that is less costly in terms of cost effectiveness, the speed, the flexibility, the confidentiality, but also what was being pointed out also, the possibility to maintain continuous relationship, the social cohesion, and promoting doing business, but also the easy enforcement of settlement agreement. The promotion of mediation in the courts is also, it has also various impact, as it was also been pointed out, to reduce backlogs, that would have increased, but by reducing, of course, the backlog in the courts, this is increasing the quality and the efficiency of court process. As echoed earlier, the law relating to the procedure of civil, commercial, labor, and administrative cases was amended in 2018, and it created a room where a court registrar, judges, or private mediator can mediate parties at any stage of court proceedings before the final decision of the court. I will not go through the statistics, but there is increasing really, even if we are starting on a lower basis, but there is, as the Chief Justice Emeritus just said, we are encouraged by the trend. We hope that more people will be using mediation as a preferred dispute resolution. I would say that there is even no alternative if we can see the trend across worldwide, especially with complex disputes. Let's take an example of construction dispute. When you have a complex construction dispute, it is rare that you will not be using a combine of method to resolve this dispute. So we see more and more practitioners using more than one dispute resolution mechanism. So you may use mediation and reserve for some aspect of the dispute and reserve other matters for litigation. It is not excluded. And we know also as arbitration practitioners that we use some time also to start with mediation, resolve some issues, and reserve others for arbitration. So there is no way that someone, nowadays a lawyer can say, oh, I am not embracing mediation because, me, I am more inclined to litigation. You are missing the trend. You will be missing the trend because when it comes to complex dispute, you may be using different dispute resolution mechanisms as we are seeing. But as I said, we are very privileged to have Bruce Edward with us, and I'm sure that he will share his very rich insight on this matter. During this week, we will have ample time to share experience, knowledge, and success stories of mediation in court. It is also a good time in hastening the awareness level of the masses, more litigants on mediation in court. This week will also focus on advocates to enhance their skills in mediation, advocacy, and to support certified mediators in developing their mediation careers path through continuous learning from practice. We will also seize the opportunity to interact and exchange ideas on the mediation in court with specific sectors. We will have a special session with the financial sector, which is an important sector where consumer disputes have an impact on the life of many citizens striving for their economic development. And of course, statistics shows that a big percentage of court cases registered in the commercial courts, especially in the commercial high courts, are coming from the banking and the financial sector. Lastly, this week, we will reflect and discuss on some challenges which hamper the promotion of mediation in courts. And I am sure together we will find some resolutions and recommendation to the relevant authorities. This will reinforce mediation as one of the best ways to increase access to justice, given the aforementioned core attribute of such a method I just mentioned, as it was also mentioned by other speakers: affordability, efficiency, accessibility, flexibility, but also the confidentiality of the process. Distinguished participants, I don't want to take much of your time. I think we have also, having heard from the president of the Bar Association, having had with a word of wisdom from the Chief Justice Emeritus. Mine is to tell you that, especially distinguished senior advocate here, that you will not think of, don't be lukewarm as far as mediation is concerned. Just embrace mediation, you'll see afterward. Maybe if God willing, after 5 years, 10 years, will be telling me, oh yeah, you were right to tell us not to be lukewarm as far as embracing mediation is concerned. On this positive note, this morning, it is my pleasure to declare open but also the starting of this judicial week. Thank you very much for your kind attention.
I'd like to thank very much my Lord the Honorable Chief Justice for the remarks that have been very profound and be very kind to officially open the mediation week, this aspect. And we've come to the conclusion of our segment this morning. Those that have joined us, we've concluded the rest of this, and we're going to transition to our other part. But before that, as I said, we'll have a segment of a photo session, and then we'll proceed with a coffee break. But help me give a big round of applause to all the presenters this morning, please. Thank you, and thank you very much, and thank you all for coming up to show up to attend on this. So we're having a photo session in this location. We can't go out because it's drizzling out, and we have some other interruptions outside. So the protocol have advised us that we're going to be having our photo session here. And because our space is a little bit small, we'll only be having tables that will be coming and have a photo and then go. So we will request protocol to usher us out. We will have the first table, please, to come in the front, and then the rest will be joining you in that order. Please, protocol, help us. And at the first line, we'll also be requesting Madam Susan to also join us, and Bernadette, and please be on that line. And then we'll request 3 tables to come and take a snap with them, and then yes. Protocol, please, we'll try to make this very fast and yes. Okay, and then the 3 tables that the protocol will show, please come very fast and join our guests for the first slot. Very fast. The first 2 tables in the front. Protocol, help us. Aphrodis, help us to make them line up very fast. Aphrodis. I think okay. Okay, whenever you're done, you let us know, and then okay, thank you so much. Please, the next 2 tables, very fast. The next 2 tables, very fast. So we advise, because of time, even the rest that are at the back, please come and join and help us. Those that are at the end, all please come and join in the photo, and we end this session. Very fast, we want to spare our time. So Aphrodis, help us make the participants line up very well for the photo. Yeah, there's still some space this side. Everyone can join up. The rest game, I won't take a lot of time introducing, but as speak that is a very good friend to the judiciary of Rwanda, the justice system of Rwanda. And myself, I had a pleasure to shadow him when I was in San Francisco, California, doing my fellowship on mediation, and I really got tremendous skills and insight, especially when he's mediating very complex issues in that aspect. So we are very profound and happy to have him, our keynote speaker. And without further ado, I'll request Mr. Bruce to please come front for that. Thank you very much. We'll welcome him up. And together with him is going to be joined by Mr. Counsel Emmanuel Butare. He's the first discussant. Please welcome on the podium. Counsel Emmanuel Butare is a senior counsel from MRNB and is also a mediator, and is very skillful in this, and is going to be the first discussant. And the second discussant is Mrs. Benedette Wicheza. Please, Mrs. Benedette Wicheza, if you're in the house, you're welcome to join the panelists. I think she has stepped out briefly, but she'll also be joining the panelists. And our able moderator for this session is Mr. Victor Mugabe, the KIAC Secretary General. Please welcome him on the stage. Please. So without further ado, I will hand it over to the moderator of this session to do his thing as the rest will be joining him. Thank you so much. Madam Bernadette, please just come straight on the panel. Thank you so much. So after this, we'll have a Q&A session before we conclude this segment. Thank you so much.
Thank you, MC, Justice Harrison. Honorable Chief Justice, Chief Justice Emeritus, thank you very much for giving me this opportunity to moderate the first session of today. The session of today is entitled The Role of Lawyers in Mediation. Thank you, MC, because you facilitated my work, because you have already introduced the speakers, and I'm not going to take much time of the participants here. I'll go straight to the topic. I think the topic is very relevant because in every dispute settlement processes, we all know the role that lawyers play in that regard. So currently, as the government of Rwanda has adopted the ADR policy, I think now this is high time for all of us here, lawyers, judges, all the stakeholders to play their role. So this morning now, we are going to talk about the role of lawyers in mediation processes. I know that briefly, lawyers in mediation processes play a very significant role in assisting their clients in reaching an agreement. But given that the professional mediation in our context here is quite new, we think that we getting the insights from one of the most experienced lawyer and mediation practitioner like Mr. Edwards is really very important, because it will guide us as we move ahead in the implementation of our policy, ADR policy. So now we are going to start with Edwards, Bruce Edwards. I know most of us knows him because he has been our trainer since the last 5 years, I think, when we started the capacity building for professional mediators. I think more than 90% of the trained professional mediators in this country have been trained by the Edward Mediation Academy. I think this institute really deserves a round of applause from our side. So now, being our keynote speaker now, I'm going to hand over to you so that you can tell the audience what you think the role of lawyers in mediation process should be. Thank you.
With your permission, I'll stand. Thank you. Honorable Chief Justice Emeritus, President of the Bar Association, and all the others who have given us such a warm welcome and a kind introduction. I say thank you and hope we can live up to that introduction. On behalf of my wife and business partner, Susan and Bernadette, I think Susan and Bernadette should get a round of applause because of the people who are responsible for the day-to-day training and all of the work, hard work that goes into what we're now discussing. They're the ones that are doing the lion's share of that work. So I stand here largely because they've been so successful working with each of you. I always like to start conversations by asking the question, why are we here? Why do you want to listen to me? Yes, I've traveled 7,000 some miles to sort of share with you what I can, but why is that important? And as mediators, we're always kind of looking to understand that question, why? What are those needs and interests that lie beneath the surface, those things that we want to pay attention to because they give pause for us to think about why the conflict that's ripening in front of us has gotten to that point. Like you, I've been a lawyer for 43 years, so I speak your language. I understand a lot of your perspective. Obviously, culture's different, states and countries different, judicial systems differ. I get that. But I've had the privilege of teaching in over 30 countries now, and largely a lot of the conversations are the same. What's the best way to implement mediation? How do we bring skill and training to the mediation population so we can serve the need? And importantly, how do we address the key stakeholder group that's necessary, if not essential, to implement mediation? That's you, the lawyers. And I can say almost without exception that the vast concern that many countries have in trying to implement mediation is how do we bring the lawyers along? What do we need to do to sort of gain their participation? So let's talk a little bit about your role. And first and foremost, let there be no doubt, you are a legitimate, serious stakeholder in the success of the mediation process. And whether you're working ultimately in your firms as litigation advocates or mediation advocates, these are complementary skills. One is not exclusive to the other. I'm not here today to say that we are replacing you as litigation attorneys. Quite the contrary. When I was in a law school, over 40 years ago now, I was trained as a litigator because that's all we knew in terms of how people resolve disputes. I did walk out of my law firm practice about 35 years ago to develop this process of mediation along with others in the United States because it seemed like there was a different and better approach to dispute resolution, an approach that involved addressing conflict at a more human level by bringing people into the same space, bringing people into the same room, yes, to talk about the law, to talk about the facts, but also to talk about emotions, to talk about what lie at the heart of the conflict. And in that manner, sometimes it was loud, sometimes it was messy, sometimes it was emotional, but ultimately we were able to work through those conversations and more often than not get to resolution. And so in the last 35 years in the United States, when I first started this process, there was a backlog in our court system. It could take 3 to 5 years to get a matter ready for trial and get it in front of an esteemed judge. That's no longer the case. There was a study that came out about a year ago that showed less than 1% of civil commercial cases filed in our federal judicial system actually end up in a trial, less than 1%. In our state courts, it's a little bit more than that. It's about 4 or 5%. But the point is the same, that the need for and the opportunity for traditional litigation skills is less than it was certainly when I was a young lawyer, and certainly for those that are going to be moving forward. In fact, before I came on this journey several weeks ago, I had the opportunity to speak to a group of deans of law schools in the United States, and my message to them was simple. We need to train the next generation of lawyers. To do that effectively, we need to train them in mediation advocacy skills, because that's what's lacking in my experience generally, is seeing lawyers come into the mediation process less than fully prepared to effectively advocate for their clients. We're going to talk a little bit more in a few minutes about what that looks like. But the point is this. The point is, for us to be successful in moving forward as a profession, we have to adopt a broader range of skills. And I don't think for a moment I'm going to convince you today necessarily, but I do hope to light the fuse of interest so that you can gain the experience. Because life is experiential. And I can tell you this, once you go through a mediation process and you start to see the almost magical things that can happen when the process is properly shepherded by a trained mediator, you will become a true believer. And it doesn't mean that it's right for every case in every circumstance. But last year, the company that I work for, we mediated about 18,000 cases around the United States, some of the most complex cases in the country. Banking failures, huge construction projects, mass casualties and shooting events, unfortunately. But some of the biggest, most complicated kinds of cases were brought to mediation and successfully resolved, sometimes in months, as opposed to the years they would languish in the court system. So mediation is here. It's coming. I just came from Cairo, and before that, Dubai. We're on from here to Zambia. In all of these countries, there's a progression. There's a movement toward mediation within bar associations and the judiciary. The question is simply, what's it going to look like when it gets here? When's it going to arrive? How successful will the local bar association be in embracing it? And you know, my background was in psychology before law, before I went to law school, although I always thought I wanted to be a lawyer. But I found learning a bit about psychology at the time was helpful. Little did I know what an important role it would play in my later career development. But as one who thinks about things and looks at the world through a lens of a psychological perspective, I sort of asked myself, what's the basis for lawyers pushing back and resisting the implementation of mediation? There's some classic examples, by the way, around the world of when people tried to introduce mediation in different countries and it didn't work for a variety of reasons. In India, about 20 years ago, they tried to implement mediation in a mandatory way. Lawyers sort of barricaded themselves in their law firms and literally went to a mediation center and started throwing tables and chairs out the window. I mean, there's examples of that where people have not appropriately reached out to collaborate and understand what the lawyer's concerns are. And my sense is this. My sense as lawyers, we're used to working in an environment that we understand, litigation. It's what we were trained in, it's what our law firms schooled us in, and now here comes somebody who's asking you to learn something new and different. And for many of you who have been going through our mediation training, you're learning just that, what that process is, how it looks different, and ultimately how it's successful. But for many who haven't had that education yet, it's fearful. I liken it to a situation where if I had an illness and I went into a hospital and I was sitting in a waiting room kind of wondering what was going to happen next and nobody was talking to me, I would have a certain level of anxiety. Just the other day on my trip here, I sat on the tarmac in an airplane for about an hour waiting for some message about why we weren't taking off. We're used to being in control as lawyers. We're used to being in control of our clients. And now being asked to participate in a new process is one that carries a certain amount of anxiety. That anxiety can be addressed by learning, by education, by understanding how to navigate the process successfully. And yes, as we'll talk about in a few minutes, it sort of involves a different mindset. But first it starts with understanding what this process is and how it needs to be navigated. And look, as a former lawyer and one who's trained lawyers now for almost 30 years, I do understand there's an economic reality to all of our lives. We all need to practice. We all need to make money and support our families. And mediation is a successful profession. Let me say it again, mediation is a successful profession. It's a situation where mediators in the United States do very well. We have lots of retired judges in our country who retire early to come in to practice mediation, partly because of the economics, and lawyers who go to the mediation process make money as well. It may well be that as we move forward in this new field and mediation evolves as a profession, that it's incumbent on all of us to put our brains together and think about what are appropriate ways of being compensated for the value that you bring to a client in resolving a dispute successfully through mediation. Because after all, if you've done that, it generally means you've saved your client time. It means you've saved your client money. You've probably saved them a certain amount of emotional distress in the process. And just maybe you've helped them deliver a creative solution that addresses their needs. And all of those things have value to the client and should be compensated appropriately for the lawyer. So that's a different day's discussion, but I do understand that that lies at the heart of many people's concerns and fears. And if we can line up the economics of the legal practice, the legal profession, with the interests of mediation, there'll be no turning back. In the United States, that has slowly evolved over the last 3 decades, so that it's no longer the type of concern. I forget which of our esteemed speakers was saying earlier, it might have been the president of your bar association, who was talking about those lawyers who are successful in mediation. More and more clients come to them because they become known for being able to deliver timely, cost-effective, appropriate solutions to disputes. And what they lose in an individual case, they make up in volume. So that's one of the themes that we address when we're trying to talk to lawyers about how do I get paid for this new process. But do understand it's the process itself that's magical. It's not my intervention every day. It's the fact that we have a process that brings us back to the roots of our profession as lawyers, being able to deliver timely, economical, appropriate results for our clients. 150 years ago, 200 years ago in the United States, one of our presidents, Abraham Lincoln, spoke to that as a lawyer himself. He said, avoid litigation whenever possible, bring people together, talk about solutions. And yet somehow we got away from that in the United States. And now we're coming full circle. And for those countries like Rwanda that have a rich tradition of dispute resolution at a community level, I was talking to one of the reporters a few minutes ago during the break, I said, Rwanda has this great tradition of dispute resolution at a community level. What we're really doing is taking that same concept and building it in the broader context of a more developed society and bringing now mediators into the conversation, because those are people who can perform the services that used to be filled by village elders and others of similar sort. So the question is then, what do you need to know as a successful mediation advocate? How is it different? Because as I said already, they are different skills. They're complementary, they're supportive, at times they're overlapping. But those of you who have taken our courses, you know, I'll give you an example. There are several skills. I won't go into too much depth at the moment, but I'll touch on them. It all begins with a different mindset. A litigation mindset, what have you all been trained in? If you were like me 30-some years ago, you were trained in wanting to be victorious. And if that came to the detriment of the adversary on the other side, and you won 100% and they got nothing, that was okay. That was how we were trained. Okay? But there's a cost to that. There's a human cost, there's a financial cost, etc. And what we've learned over time is those successful mediation advocates have a different mindset. Their mindset is one that's more toward collaborative problem solving. It's how can I win and help you win at the same time? It's not a zero-sum game or winner-take-all solution. And so it begins by retraining how we think about finding solutions to problems, because they're more often complex, sufficiently complex, so there isn't necessarily a clear winner and a clear loser. The question is to find where in between we can come together. And that's a mindset that starts to shape your interactions as you move into the mediation process. Beyond that, there's different skills. We talk a lot about listening in mediation training, you know that. In the litigation context, we listen for a specific purpose. We listen to try and identify the other side's vulnerabilities, to fashion arguments, to defeat those arguments that are made against our clients, and ultimately to try and prevail. Sometimes by talking more, sometimes by talking louder, but ultimately it's a different type of listening. In the context of mediation advocacy, you've got a completely different type of listening. You're listening to develop some degree of connection. You're listening with curiosity, perhaps to hear something that you haven't heard directly from your own client that would impact your assessment of the dispute in front of you. You're listening with a certain degree of compassion and empathy, because that's not mutually exclusive with getting a good result for your client. So just in that one example, just taking that one skill of listening, you see how litigation advocacy and mediation advocacy differ. And that holds true for a lot of the skills that we try and teach mediation advocates, whether it's being creative. You know, the best mediation advocates are thinking about the art of what's possible. They're trying to understand what their clients need. They're trying to understand what the other side needs and figure out where that sweet spot is for a creative solution. As opposed to litigation advocacy, where you're constrained in your judicial remedies, you know what's available, and you have to fit into that sometimes narrow subset of remedies, as opposed to the broader context in mediation, where it's the art of the possible. If you can think about it, if you can dream about it, if you can get people to agree on it, it can work. I once had dinner with Bill Urey, who's Dr. William Urey at Harvard, who wrote the books Getting to Yes, Getting Beyond No. Perhaps you've read some of those. And he was talking about his work in the country of Colombia as they were setting about to mediate the dispute, some 50 years in the making. Talk about a long dispute. 50 years in the making with the FARC rebels. And they were finally sitting down with the FARC rebels trying to negotiate a truce and ultimately how they could move forward in peaceful coexistence. And Dr. Urey was sitting with the government negotiators, and they were ready to advance their positions, just like you as trained litigation advocates would advance your positions. And he said, no, we're not starting there. Where we're going to start is with a conversation about what does the other side need to take back to their constituents at the end of the day for this discussion to be successful. Let's think about what the other side needs first, then we can talk about what works for us and begin the conversation. Again, a subtle difference between litigation advocacy and mediation advocacy that sort of sets the tone. And I could go on in terms of the various mediation advocacy skills. We talk about people needing to be prepared yet flexible. The best mediation advocates are both. They're prepared, meaning, and you'll hear in a minute as I go through just a couple quick examples, things that mediation advocates should do in preparation for mediation. And the best mediation advocates do that preparation, but then they show up at the mediation with a degree of flexibility that reflects what's playing out in front of them. In other words, they're not tied to a particular script, but they're flexible enough to tear up that script in certain instances and respond to what's happening in front of them. I once had a number of mediations for a lawyer who represented the John Deere company, the company that makes farm equipment and forest equipment. And their company, because of the types of equipment that they made, often found themselves getting sued by people who were horrifically injured by this large equipment. And when I would come to mediation with him, he would come in the room, and before we began the legal discussion with the advocates, before he began by talking about whether there was a product defect or whether there was negligence or some other legal theory, he would address the other side and simply be human. In other words, he would demonstrate a level of emotional competency that really was far ahead of his time. He would say to the other side, look, I'm sorry we have to be here today. If I could turn the clock back, I would be the first one to do it. Nobody in our company builds products because we want to see them hurt people, and we're here to try and do what we can to make things right, given that we cannot turn the clock back, given that your client was horrifically injured. And we'll work as long and as hard as we need to try and make things right today. But I just wanted to say that before we got down to the particulars. And then he would sit down and be quiet for a moment. And you could feel some of the poison just come out of the room with that brief statement that he made. And that's a sophisticated mediation advocate, understanding what works both for his client and for the other side. He could have gone into a more traditional debate with the other side that might easily have ratcheted up into a loud, angry disagreement. But he chose a different path. And he chose a different path because he understood how mediation worked and what he needed to do to get a win for his client. So those are the kinds of subtle distinctions between various skills that are trained in a mediation advocate versus a litigation advocate. I want to be respectful of time because I know I've got esteemed colleagues here on the Diaz who deserve an opportunity to share their wisdom and experience, and I certainly want to leave time for plenty of questions. I do want to share with you from a mediation advocate perspective a couple of things you should be thinking about. And it starts from the very beginning. Many of you who have taken our courses know that we have a chronological development of the mediation process, beginning with the convening stage, those things that happen before people end up in the same room having a discussion. And the best mediation advocates know that there are certain things that have to happen that they need to do well in that convening stage to be successful later on. Starts with preparing their own client. If you think as a lawyer you're uncomfortable coming into a mediation process, imagine the client. The client is the one who's hired you, particularly, I don't know, I hope you're familiar with the Star Wars movies, but they've hired you to be Darth Vader, you know, the person that wears black and is angry and fighting the good fight. And that's what they expect a lawyer to be. It's incumbent on you as you move into the mediation process, though, to reshape their expectations, to say, I can be that person. There may come a day where I have to be that person, but that's not today. This day is different. This day, you're going to see me adopt a different approach. I'm going to take a different tact altogether. You might even hear me agree at times with the other side, and that's okay, and here's why I'm doing it. And so you need to engage your client in a very robust conversation about what the mediation process is and about what his or her role will be in that process. One of the things that we do in mediation, those of you who have been through it, it's designed to bring people into the room, including clients, to encourage their participation, all the way through to the very end, where we ultimately ask them to make a decision that may impact the rest of their lives. And so it starts from the beginning with you as mediation advocates, sharing with your client what you expect them to do by way of participation. Also, in the convening stage, as lawyers, what do? We write briefs, we write memos, we do a lot of writing. There is a unique opportunity presented in mediation to provide a mediation statement to the mediator, advancing your client's perspective. Many lawyers don't do a good job. Many lawyers don't do it at all. Many lawyers will hand me a complaint to say, here are all the legal theories that are spelled out in this court document. Again, they miss the opportunity. This is an opportunity to hand a document not just to the mediator, but to present it to the other side for them to consider well before people walk into the mediation room itself. So there's blogs on the Edwards Mediation Academy website on how to write an effective mediation brief. I encourage you to read that. I encourage you to become a student of the things you can do to be effective in that pre-mediation stage. But writing a mediation brief is a separate conversation of its own. But the type of information that goes into that brief, how it's presented with a tone that has both a degree of advocacy but a degree of collaboration, is a nuanced skill that most mediation advocates in my country have yet to master. But it is something that needs to be addressed further. When you get to the day of mediation with your clients, they obviously are prepared. You have schooled them in what's to be expected. Ideally, you've talked with the mediator before the day of mediation so that you're all on the same page in terms of what the process itself will look like. You've probably even participated in designing that process, meaning you're suggesting whether it is a beginning with everyone together or it's a sequence of some private meetings first. Whatever that process is going to look like, you are in charge of designing that process. Don't think for a moment and don't agree with a mediator who says, I only do it one way. Part of your expanding role as a mediation advocate is to become familiar with different processes, to participate in designing that process that's best for your client on this day under these circumstances. And that's part of the skill you'll develop in mediation advocacy. But back to the moment when we walk in and Justice Regege and Bernadette are there at the head of the table mediating a case, and you're the mediation advocate, you need to have adopted a tone that's appropriate for that circumstance. You're not going to stand up, even though he's an esteemed former justice, and deliver an opening statement as though you were in a court of law. You're going to adopt a different tone, a less formal tone. The way you address him, the way you look at the other people in the room is going to be distinctly different. Think about this for a moment. Picture yourself as a mediation advocate with your client at your side, and you're looking across the table at the other people who are not just in conflict with your client, but have the ability to resolve that case today. This may be the only time in the life of this litigation where you have the opportunity to address those people directly. That's a huge opportunity and a huge responsibility as a mediation advocate. So you need to prepare appropriately so you can deliver the message to the other side or sides in a manner that they can understand. That means avoiding the kinds of irritating comments that we as lawyers often make, the kinds of denigrating statements that speak to hyperbole and lack the kind of credibility that we should bring to that moment. The more candid and truthful we can be means you gain credibility with me as the mediator, which is no small thing, but it also means you gain credibility with the other side. So be thinking about that extremely important moment in mediation when you're asked to give some opening remarks. As the process goes on, I'm not going to belabor this because it's a course unto itself, but how you participate in the negotiation part of mediation is a completely separate conversation. How you prepare a client for a negotiation and his or her expectations versus what actually transpires when those expectations are not being met in mediation and you're being asked with your client to adjust your positions, that's a different conversation entirely, but a tremendously important one, because this is where the rubber meets the road in the mediation process, when people come together and begin that negotiation to see what might be possible by way of a solution. And ultimately, if you're not quite successful on that first day, there's often a follow-up that's involved in mediation. And the best mediation advocates know how to keep a mediator engaged, how to keep the other side engaged, how to keep the fire burning, if you will, so that what begins on that first day might ripen. I had the privilege of taking His Honor, the Chief Justice Emeritus, in a mediation when he was in San Francisco last September. And it was a case involving a class action lawsuit by residents in the state of Hawaii who had purchased air conditioning units from a South Korean manufacturer that were alleged to be defective. And we didn't make progress on that day beyond simply going back and forth between parties. What I haven't told His Honor yet is that that case came back to my office about 3 weeks before I left. We engaged in a 14-hour session, barely with breaks, and have gotten that case now to the cusp of settlement. So the best mediation advocates know that you're patient and you don't give up in this process, because it doesn't always evolve in a single day, particularly those cases that are complex or involve multiple parties. So my hope this morning, and as we move into this afternoon with some more practical skills and opportunities for you all to be involved more directly, you're not just listening to me, I hope we'll light the fuse. And I hope we'll light the fuse that gets us to a point where you appreciate this is the future. And I've seen it in my country where people who didn't get on board early on were left behind. Clients left them. Clients, literally stories of corporate clients taking their entire inventory of litigation from one law firm to another simply because that new law firm had embraced mediation and was really willing to give it a try. Many of those same lawyers early on, when I started mediation, who would slam the law firm door in my face when I came trying to talk to them about mediation, in the years since they've found their way back to me and asked if I could give them a job as a mediator because they see the value in the process. So it's an evolution. And in the United States, with 400 years of legal history going back to our roots in England, we've been able to change the judicial culture in less than 30 years, to the point where mediation is required in most courts before people can go to trial. Most contracts between banks and consumers, between participants in a construction project, between professionals and their clients, they all have mediation clauses. And so that takes some of the challenge away from mediators in recommending mediation. They simply pick up the phone and say, the contract requires us to have a mediation dialogue. When do you want to do it? And that now is ingrained in our judicial process. That's the future. The question is just, when does it arrive? And to what extent are you there waiting for it? So hopefully you'll recognize this conversation today as an opportunity to expand your professional skills and get back to the roots of what, hopefully like me, brought many of you to this profession, which is an opportunity to try and help those in need in a way that really addresses their needs and interests. So I look forward to this. It feels like for Susan and I kind of coming home. We've lost track of how many times we've been here now, but as I was listening to the esteemed speakers this morning, my first thought was, wow, how far you all have come. And I don't mean that in any derogatory way at all. It's just the reverse. It's It's almost like an aunt and uncle coming from a distant town and seeing how nieces and nephews have grown up in their absence. And that's what I take away from listening to the conversations about the depth of your learning and the support from the judiciary and the Bar Association and the pathway that you're on. And Susan and I stand committed to continue helping you all in your learning journey. So we look forward to today and the week beyond, but thank you for listening to me.
Thank you very much, Bruce, for your insightful discussion. It's really very important to learn again from you, because what you've said, I think most participants here have already benefited from his interventions during the mediation courses. And I think today it's really an add-on, and I kindly request you to note some questions that may be arising after discussion, because his presentation was very short but really concise and contains a lot of tips that we lawyers should live with after this session. But before we continue, I request you to take some notes, some questions, so that can be raised after this session. So after now the intervention from Bruce Edwards, we do have now two discussants. I think we are very familiar with. We have Senior Counsel Butare Emmanuel from the MRB, one of the leading law firms in this country. I think he's a senior legal practitioner, and as far as I know him, he's also an area practitioner in mediation and arbitration. We also have Madame Bernadette, who is part of the Edward Mediation Academy, because he has been facilitating the training in mediation. But in addition to that, you should know that she's the first Secretary General of the Kigali International Arbitration Center. So she has that extensive experience in ADR practice in this country. She's the pioneer of the center. And personally, I really thank you for your support that you provide with me every single day that I need your support. I really get it. So we do have really with person that are very conversant with topic. So now I would like to now to go to Madame Bernadette, the first discussant. After the establishment of the Court Annex Mediation Advisory Committee, the committee recently visited a number of courts in this country just to assess the level of implementation of the system in courts, where you interact with the judges, where you interacted even with some lawyers in some jurisdiction, met some lawyers. But I would just want to ask like two questions regarding the findings, concerning the findings that you met during your recent tour. And my first question was to ask, what are the key challenges, I know that the challenges are too many, but what are the key challenges that courts face in referring the filed cases to mediation? That is the first question. And the second one was to know about now the collaboration of the court management, the judges, and the lawyers, because here we are talking about the role of lawyers in mediation processes. What is the current situation with regards to the collaboration between the courts and the lawyers regarding the implementation of the court annex mediation system in this country? Thank you very much.
Thank you, Honorable Chief Justice, for this opportunity to share with the audience what we learn from court and what are the solutions we tried to develop and to share with stakeholders here. I will be supplementing here the Chief Justice Emeritus. This morning he shared the challenges we in our finding, in our discussions, what were the challenges that were raised by court staff, judges, and the registrars, and issues in relation to the collaboration with advocates. First of all, we realize that there are different practices. In some court, even judges and registrars tell lawyers, we don't need you, this is mediation, right? So we don't need lawyers, we need just parties to work with us. And what we did in our discussion with them is to tell them lawyers are partners in this process of mediation. They are advisors to the clients. Lawyers are bringing case in court. So you should try to put them on your side. So we are in an education process within the court system. They have also to learn that this collaboration is important. This is to assure you that the judiciary is committed also to continue educating judges and lawyers on this mediation system that require collaborations between lawyers and judges at the beginning of, at the phase of referral of cases to mediation. This collaboration means that they have to talk to lawyers instead of telling them to go out. Yes, if you are practicing in court, maybe you met those situations where judges are telling you to go out of the court. So for others, we realize that there is a problem of discussing the issue of compensation when lawyers are in mediation. And we realize sometimes lawyers that are coming in court are not informed about the compensation system we have established. Judges don't know that if a case is being mediated by a private mediator, there is some, I'm saying a compensation because sometimes there is a lot of work, and the schedule of fees that has been established and approved by the judiciary, it's a little money in comparison with the work that is involved. But our situation is not different from other jurisdictions. For example, in Kenya, the court fee paid to mediators is around equivalent to $100,000 at the level of the High Court. But still they are mediating cases. They have around 700 mediators, and those mediators have accepted, sometimes senior lawyers, to be paid $200,000 because they know we need to build our system before it becomes beneficial. We have return on investment. We have to invest in the system. So we realize that this is one of the issue of collaboration. Judges and registrars are not informed about the mediation system. You know that we have the Chief Justice instructions governing mediations. Sometimes we ask people, how many have read those instructions governing mediation? And there were 2-3 people in the room informed about these instructions. We think then it is important if yourself, as mediation advocates, you are informed about the structure of mediation in the court system and the process and the benefit, and you are able to educate also judges and registrars in the court. The same what we, at the level of our advisory committee in our visit, what we did is also to raise awareness within the court staff about the structure of mediation. And we asked the president to take the lead, to put aside sometimes to discuss in a reflective group within the court staff on mediation, what have their experience, how they refer cases to mediation. So this is to show you other things are being done to improve your collaboration with the court staff, judges or registrars, in order to improve the referral to mediation. So the issue of compensation, sometimes it seems that lawyers resist mediation because they don't know how they will be paid when they go to mediation. So what we discuss with judges and the registrars is sometimes to try to openly discuss the issue of lawyers. What is going on? Because if a lawyer resists mediation, that means they have concerns. And then they are part of mediation, they are stakeholders. So we are not only looking at the interests and needs of the parties, sometimes at the beginning of our system, we need to engage lawyers on their own concerns. And some judges are trying to pay attention to that. Even we have experience in commercial court when a judge mediating a case, just because of the facility are not easy to use, this judge took the lawyer outside in the parking to discuss in a separate session the issue of fees. So those are things we are discussing with judges and registrars in our visit, the issue of compensation that can be discussed openly, the collaboration of lawyers. We want them to be informed about the schedule fee. If we are in a mediation in court, before going court for litigation, as mediation advocates, you should also be informed about this schedule fee, because sometimes I see on the group WhatsApp court mediator somebody asking, where I can find the information about the fees paid to the mediator. So those are things we think we need to be able to know now at this stage, how mediation, and to inform also your clients. In some countries, I have seen a mediation legislation, including the provision that lawyers have a duty of information to the client about mediation. So we don't have this legislation, but maybe senior counsel will explain what you have in your legislation that talk about mediation, and you can use to discuss with your colleague, because this session has been organized with selected senior lawyers who we believe will be ambassadors and influencer in your profession. We hope that you are taking seriously this mission of educating your confrère, you say confrère, right? Your confrère about the minimum knowledge, the minimum tools they should use, because you will be meeting them in court. So we observe also the issue of case management, how judges and registrars refer cases to private mediators or to mediation. Sometimes they don't know. We met some judges in court who don't know even the form to be used in referring cases to mediations. So we tried to give them the tools they can use, the form of a settlement agreement, so that they can have a sustainable, enforceable settlement agreement. The form of the court order, I hope you know the court order entering mediation into a judgment. You have seen it. Those are the tools also you should be, you should know to support your clients. There was also this problem when you receive a case referred to mediation through this letter from a judge, sometimes you don't have supporting documents. So you need to collaborate with the judges or the registrar that referred the case to you to have additional information. So we are working also on this collaboration in case management to make sure that when you receive a case for mediation, you have also a minimum information about the case, or because sometimes they refer the case to you and the lawyer doesn't know that his case has been referred to mediation. So at the judicial level, there is also this work of educating judges and registrars on referral to mediation. I think there is also a pipeline of training specific to referral to mediation. How judges and the registrar work with parties, engage in a conversation with parties to create a willingness to come to mediation and to participate meaningfully. So this is the role, the specific role of judges and registrars, and there is a process of training the team, the court staff, specifically in referral to mediation. There is a training program on referral to mediation that is going on in partnership with people from Netherlands. So mainly those are our issue the judiciary is working on. So this education process is not only for lawyers, but also is for judges and registrars to improve collaboration. But also they told us about the public awareness, because sometimes court staff and lawyers are also facing resistance from the users of the court, litigants. So this is the reason why this mediation week include also a day for mediation and communication media about this mediation week, and call for litigants to come to mediation so that the case are concluded quickly. So mainly, I think I move on my time. Those are issues that has been raised in the court system and the plan to address them. Thank you.
Yeah, thank you very much, Madame Bernadette. So I think really having noticed this kind of challenges, which in my view, I think they are based on the understanding, the lack of awareness, lack of knowledge, lack of skills. So I think those are really challenges that can be addressed. That's why really I remain very optimistic, because it's just a matter of educating people, educating practitioners, educating courts and judges, because we've noticed some issues regarding the court's understanding of the role of a lawyer in mediation processes, which is very key. The issue of compensation, the case management, and kind of referral, the training on referral system that should be addressed. But there is an issue that has been very been repetitive in the mediation process regarding the issue of fees of lawyers. So that's why when I go to Senior Counsel Butare, I have a couple of questions, but I would like to start on the issue of fees. I just want to know from you, so that's the first question, if there is any, I mean, as a practitioner on mediation and arbitration, ADR practitioner in general, what would you like to say about fees in mediation by a lawyer? That will be the first question. Maybe I'll ask the second and the third question after you have responded to that, because that is very crucial. Thank you.
Thank you very much, Victor. My Lord, the Chief Justice, and you allow me to address you seated. I know I'm supposed to be standing. Professor Sam Rujeje, Chief Justice Emeritus, Mobatonier, Edwards, colleagues, I think mediation is very new. It's very new in our jurisdiction. I'm talking about mediation. Of course, we have been having other processes of resolving conflicts which are very traditional and which were very effective and efficient. But when you talk about mediation, I think it is a completely new concept, and which is very, very good. Of course, the issue here is about lawyers. When you look at the topics within this mediation week, it is actually centered around lawyers. What is the role of lawyers? Meaning that actually lawyers, they have a very, very critical role in terms of advancing this advocacy on mediation. And worldwide, the people know lawyers as people who make a lot of money. I don't know how far true that is. Meaning that if there is anything that you are bringing on the table, there must be compensation for that. Now you're talking about mediation. Lawyers, we are used to litigation. And we only get our money through that, and probably other legal work that we do. But I'm very sure that lawyers not being proactive in mediation is actually the issue of knowledge and the need for sensitization. We know, of course, through the training, apart from, the techniques on litigation, what you have to do, how you have to raise your voice, whatever you have, all of those tactics in litigation. We definitely have some courses that we do, which are, out of litigation, which are based on ADR, including mediation. So, meaning that if as practitioners get to know that actually mediation is also another source of income, then everybody will get to know into it. Now, why are fees very important or are a concern to lawyers? Most of my colleagues here will agree that when we are drafting our legal, the legal service agreements or contracts with our clients, I will be representing you in court, and I will charge this much in this court. When you go to the appeal level, I will charge you this. When you go up to the Supreme Court, I will be charging you this. That is the standard legal service agreement that most lawyers actually have. Now, when you introduce an issue of negotiation or mediation, it does not feature in the contract that you have with the client, and it becomes a concern. Well, the contract I have with the client is about representation in court. There is nothing else in between or before that. So how am I going to invoice or to bring in the fees for whatever that is going to to be done. Now, at least as far as we are concerned, today the contracts we do, you actually include the first phase of mediation. You can have that in your contract with your clients. So that instead of starting with going to court, you start with mediation. In case this issue is resolved out of court, then you are going to be paid this much. Now, if it escalates, if it goes to court, and it probably gets resolved before, out still not by the judge, you still get paid. So I think if this is introduced in the contract, you will not have an issue of your fees in terms of what you get paid because you have been referred to mediation. As simple as that. I think if this is done, we are not going to have issues, lawyers resisting mediation. Because in most cases, the resistance is because the mediation phase is not reflected in the contract they have with their clients. I think once this is done, we are going to see most of the lawyers embrace mediation and not resisting it being done. And of course, for obvious good reasons that Edwards mentioned, and probably I know most of the people in the room are actually trained mediators, so you definitely know how good it is to go into mediation than going into litigation. So I think that is one way that we can have this issue of the fees resolved. Now, that is an issue of fees for lawyers. Now, there is fees for lawyers who are mediators. That is another concern. Even for mediators who are lawyers to actually take on some cases. Of course, we have the scale of fees for mediators. Of course, Madame Bernadette mentioned about, the money for mediators being, not reasonable enough. But again, I think when you become a mediator, this is a passion, first of all. You must be having a passion to really be a mediator. And when you have a passion, you're looking at the result more than the fee, really. But still, if you're successful in the mediation you are doing, in most cases you are going to get referrals. You're going to get referrals from, one, the lawyers that were assisting their clients before you as a mediator, and the clients themselves. Because remember, this is an open session where people are comfortably talking about anything and everything. And you as a mediator, you are there to actually help them to agree. So if what you are going to be paid as a mediator that is already there is not enough, I can tell you are going to get more from the referrals that you are going to get from the clients and the lawyers that have been before you as a mediator. I have got lawyers refer cases to me, my colleagues refer cases to me, and even, when they are in court, they say, we want so-and-so to be the mediator, because they have appeared before me before, they know what I do, and they just feel comfortable because they have been with you. So meaning that any mediation with the lawyer so-and-so, the first person that will come is going to be you as a mediator. Now, even for the clients who have come with their lawyers, they will get there and look at how you are doing your things and feel that probably this is, in one way or the other, a better lawyer. Now, that is the way how, as a lawyer, you can actually make money as a mediator. So I think it's an issue of understanding why mediation is very important, but in terms of being actually a lucrative business. And lucrative in even a better way, because apart from the money that you can make in mediation, you even get that satisfaction that you have actually resolved an issue that has been pending, that has been in courts for so many years. So I don't know how you can actually, the way you can convert that satisfaction in terms of, in monetary terms. It becomes really hard. And that's why I was saying that mediation, at the end of the day, is a passion to do good and to feel that, you know, the society is together, other than when you litigate and you win the Supreme Court. And then when you get out or you somewhere, you meet one of the other party that you are against and is looking at you as a very, very bad person. But in mediation, wherever you meet, you will be hugging. You will be very happy to each other, and that is the kind of society I think we want to have going forward. Thank you very much.
Thank you, Councillor Emmanuel. Before we conclude with you, I just want to ask you, the recent report from the Court Annex Mediation Advisory Committee from the courts, for the visitor from the courts, is that the judge may face a complaint from a lawyer that when they propose to go through mediation and a lawyer say, the lawyer say, no, I have the mandate to assist my client in litigation. And now you are proposing mediation processes. What about my fees and the preliminary works that I have done for my clients? What would you tell a lawyer that really resists from the proposal to go through mediation process, basing on that mandate, the contractual mandate to assist him before that court?
Thank you very much. I think, in principle, lawyers work under instructions. Although you might be somebody who embraces mediation, but we work under instructions of our clients. And in most cases, we normally condense that into an agreement that we sign. Now, if mediation is being introduced in court, by court and say, why don't you try mediation? I think even though you have the instructions to litigate, to represent to represent your client in court, but in presentation there is advisory. I don't think you're going to have any problem with your client if you agreed to mediation that you did not think about before, or your client did not think about. Because at the end of the day, you're looking at the interests of your client and how you can help your client. Now, if you think mediation is going to be one of the ways to actually help your client, then there is no reason why you should resist that. Because at the end of the day, what you are looking at is the end result with regard to the issue that your client has. He might even get a better deal in that mediation than you continuing into litigation. Because litigation, we all know, when you win here, you lose on another level, then it takes that long time. And then the conflicts, the confrontations, the issues between the parties. But if it can be resolved at that time, I don't think a lawyer should resist, anything to do with a mechanism that is going to be used to actually resolve the issue, here being mediation. So I would urge my colleagues that if a judge introduces, why don't you try mediation? I think we should always embrace it and say, for as long as it is going to resolve the issue I have for my client, then I have no problem. On the other way around, again, I think if a lawyer introduces, or one of the parties says, well, can we have mediation before we proceed in court? I think we should also have judges that are going to say, it's okay. Because in most cases, and of course, it happens for one reason or the other, but in most cases you find that, the defendants or respondents in cases are always going to come up and say, can we try, mediation? And in most cases, they can do it as a way of delaying the matter, but they might be doing it genuinely in a way of trying to resolve the issue. So in most cases, you find that the claimant is always going to be against that, especially if it is not been done in the preliminary hearing. That was not introduced. Then you get before the judge, and now the respondent raises and says, can we go for mediation? The other party definitely is going, so no, this is a way of delaying the matter. But it might not necessarily be. And you might find that at that point, the judge is actually convinced that this is a way of delaying the matter, and then says, no, let us proceed. So I think, again, depending on at whatever level, I think we would also need that kind of collaboration from the courts to understand, and also look at whether or not this is a way of dealing the matter or not. Thank you very much.
Thank you very much, Councillor Emmanuel. I think you have given us some tips that I think are very, very crucial. And maybe one of the recommendations to actually to address those challenges would that lawyers should adopt that strategies to include the amicable settlement services, pre-filing or court-annexed mediation, so that they can be compensated for that particular services. And he also said something very important that is similar to what Bruce said, that actually it's really, we should be very proud of being part of the solution, instead of like I've been paid such amount of money despite losing the case. But when you are really compensated on your contribution to find a solution to a problem, I think that's really very important. So I think if you allow, Honorable Chief Justice Emeritus, we can now open the floor to the audience to ask some questions before we close this session. So now the floor is yours. I can see Council Florida, and maybe someone may assist in. Okay. Yes, Council Florida.
Thank you to the panelists for the eloquent ways you have enlightened us about mediation. I have a comment in terms of, I think there's a lot of opportunities that lawyers have when it comes to mediation. It's very interesting that Councillor Butare brought up the issue of passion. Many people who come to mediation not obviously have the passion for it. But I also feel that as practicing lawyers, the first thing that needs to come to our minds must be ethics. Must be ethics that governs our profession. And that means when a client comes to you, you must necessarily tell them what is in their best interests, even if that may not coincide with your financial interest as a lawyer. And that means, yes, there must be passion, but we must also look to ethics. If, for example, somebody comes to you and they work, for example, they have a commercial contract with another party, but in reality, you definitely know this person, your client is likely to get something better, a much better deal out of it when you use mediation. Yet if you go the route of the courts, you are likely to be compensated for a much longer time because there's a lot of money involved, so it's likely to go all the way to the Supreme Court. But your client needs to protect their own reputation, so you look to the client's needs. They must protect their reputation. They must protect this relationship because perhaps the party they're in a contract with you don't find 2 or 3 of them in this economy. So when you advise your client, in fact, we are the ones who propose the contracts. Aren't we the ones who propose the contracts that we are giving to the clients? If I give you at this stage, this is how much you'll pay if it goes to court, if it goes to that. So give them that entire cocktail, but also have the professionalism to explain to them what good is in, the different cocktail of solutions, such as mediation. It is imperative that we understand this is a professional requirement on our parts as lawyers. It's an ethical requirement on our part as lawyers. So the comment I also wanted to make in terms of questions as well to Council Buta and anybody else on the panel who would like to speak to this. I am personally concerned about the scale of fees for mediators. And the reason I'm saying this is because, yes, you have passion, yes, you have ethics, but human beings, the way we are made, it is what is in it for me. It may not be the way I think, it may not be the way you think, but at least we should go to the minimum of what the legal scale of lawyers usually provides. That way, you are going to have more lawyers interested to see, okay, fine. If I can go to court at one level and get the same amount as if I go to mediation, then you're buying more people into this than doing this long term. In fact, when people actually ask us who are supposed to be in this mediation field, what is the first thing they ask us is, well, what is compensation? Let us not ignore the big challenge that this, starting this is having. So I just want us to think, if it ends at mediation and the lawyer gets compensated the same amount they would have gotten compensated at, you're likely to have more people coming to mediation and more lawyers being supportive of mediation. Because you cannot, in the human way, the way people behave and the way people think, we cannot ignore the self-interest that comes into the picture. Thank you.
Thank you, Council Florida.
Speaking here, which is near.
Okay, thank you. I'm Kagabo Venist. For me, I just want to come on the issues or challenges highlighted by Bernadette. For challenges that we are facing in courts, sometimes parties are negotiated to go to mediators. But we need something like a precondition to file a case in court as it is for arbitration. You see, when you get a client, he came with a contract that highlights some clauses of arbitration. What we observe for the first, we just tell him, you just go to arbitration. But for mediation, there's nothing. So if there is something, maybe some amendments on the law, but if there is something to be taken before filing a case in court, to be considered, to first look, a mediator will help us more than filing a case in court and then reach in a pre-trial hearing, the court registrars start negotiating parties to go to mediators. That's where the hard negotiator come. Of course, he will never accept it to go to mediator while he already choose to file a case in court. Another thing that I just want to tackle, it is what Mr. Edward mentioned as mediation. It is not time consuming. To some extent, I do not agree with that. For lawyers who know, in these last 2 years in commercial courts, we have experience where in 1 month you may file a case in court and be heard in pre-trial and in hearing, and the hearing in merits. And the next month we get the pronouncement of the case. Then in 2 months the case may be closed. However,
Thank you, Honorable Chief Justice, dear panelists. I wanted to make a few comments in as far as promoting mediation in our jurisdiction is concerned. The truth of the matter is, yes, this is a new concept to the in our jurisdiction, but when you look at the process of litigation that we've been using in our jurisdiction, you then have to agree with me that at the end of the day, we cannot continue to do business as usual. The issue of instructions that Council Butare did mention, yes, it is true. Each and every lawyer, by the time you're getting to sign your letter of engagement with your client, there is clear instructions and the scope of work that you're supposed to be doing. But if we lawyers that are involved in mediation, starting from the champions that are here, start to consider including this mediation as one of the work that we'll be doing for our clients, this can work. Because most of the time we are the ones that advise our clients. They are not the ones that advise us. So if we consider starting from that point, we can promote mediation in our jurisdiction. Coming to the issue of resistance in mediation for lawyers. You see, building a culture is something that takes time. It does not come abruptly. But the truth of the matter is, can we now have a starting point as of, like, try in as much as we can to get people to understand that mediation is something that can help in resolving quite a number of disputes. Another thing that we need to work on, Honorable Chief Justice, not only for lawyers, but all the stakeholders in this mediation process, we need to work on making sure that we get to understand that there is a capacity building need, a serious one, and not only for the legal part of it. From experience, one of the issues that I've seen among lawyers, we tend to think that everything starts with law and ends with law. It does not. I can assure you, if today Bruce is telling us that he is successful in mediation, his training in psychology should be playing a very, very big role in making him a successful mediator. A lawyer that feels that in mediation his fees are threatened will be resistant. I was speaking to the Vice President of the Commercial High Court of recent when we were having a meeting of the advisory committee, and he was complaining to me, telling me, you see, we've got so many mediation, but they are failing because lawyers do not come to an agreement in as far as their legal fees are concerned. Then I'm like, obviously, the mediation is not going to be successful if lawyers feel that their fees are threatened. But the issue here is these fees needs to be established in a clear manner and in a way that is understanding and that can be understood by each and everyone. And then, as Florida was saying, Honorable Chief Justice, we also need to look at how we can establish these scales and make it something that we attract even these experienced lawyers. How do we do it? When you look at the normal lawyers, the scales of advocate fees, we consider quite a number of things. The expertise of the one involved in mediation, the time that is going to take, I would say the value of the matter that is being mediated. So out of this, we can have a scale that allows each and every case to be found within that kind of scale, and then it comes to be an added value to the passion of the people that are involved in mediation. Because at the end of the day, like each and everyone is saying, legal fees is equally important to be considered. I would say that all we have to do in partnership with the judiciary and all the stakeholders that are here present is we have a lot of work to do to change the mindset of people, because our community also needs to be educated. There are clients who will be happy to walk out of the court by saying, you know what, Victor Namusins. And that becomes out of like ego and being proud that I won over a matter that I cannot even enforce. It doesn't add up at the end of the day. But then preserving this future relationship with this business community, we allow even our economy to grow. That is the mentality we should have, and once we do it this way, the business community is going to grow, and at the end of the day, when the economy is functioning, there's a multiplying effect that goes even to the lawyers' fees. So this understanding is the one that we should develop, all of us, and I think if we take this, if we understand this in the same way and embark on this journey, we're going to make it. I thank you.
Thank you, Batoni. Can we take one more question? Then we'll. Okay, so there'll be 5. If we take the one from Council Hilary and Council Jean de Dieu. Okay, thank you.
Thank you, Chief Justice. I'm called Hilary. I'm a mediator. I would like to say 2 things. One is a proposal. Another one is a question I'm asking. Let's come on the question said by Kagabo, Mr. Kagabo. He said that a mediation could be a precondition. I'm in his hand. I give example. Sometime as a lawyer, we help our parties, our clients, to exchange letters with the other parties. For example, if my client came and he told me that his colleague contract is not respected contract, I proposed the letter and to remind the parties to execute the contract. If he don't respond in 5 days or 10, I introduce the case on the court. The court asks us, request, is a mediation is done? We say, it's done but not successful. The court continue to the case. Is taken the case as a mediation is not successful. So what is to be done? It is to take mediation as a precondition to litigation or to arbitration, but mediation is done in a professional manner, as we studied, showing the step of mediation as not exchange the letters. Secondly, the role of lawyer in mediation is key role. Guidance, advocate, explaining legal aspect, sometimes help to write an agreement for a settlement. To be effective and efficient, mediation would be done professional. And you have seen that it takes a long time for an advocate, for the parties. A lawyer who takes a long time to advocate, to explain, to write, and they have not enough payment, it is a discouragement. Sorry for my English, it's not but I hope I try to improve it.
Sorry to cut you short. I would like, because this is an interaction of panelists, our guest of honor. I think we are free to express ourselves in the language that you can master, because what you are mentioning is very, very important, and we want to make sure that other colleagues really can hear what you want to say in Kinyarwanda, because at the end of the day, the mediation is conducted in Kinyarwanda and the challenges are already addressed in Kinyarwanda. The practitioners are, so we kindly request you to address that issue in Kinyarwanda because it's very, very important, because our speakers here, Butare, Bernadette, at least they understand. But for any other issue, may translate it into English so that our keynote speaker, Edward, or even Honorable Chief Justice may also intervene when necessary. So mureke tuganire kuko ibi nibazo tuganira bikomeye bitureba. Don't be constrained rurimi tubivuge kuko ndakeka ko turi busohoka hangaha hari nibyo twumvikanye tugomba kugira ngo ya Court Annex Mediation Advisory Committee tuzabi formulating into action plans kuko nibazo twateranya kugira ngo dushakishe umuti w'ibyo bibazo dufite n'ibitekerezo. So feel free goes. Yes, please, you can repeat the question nabandi babyumve.
Nashatse kubaza ikibazo cya mbere cyari kuvuga ngo rimwe na rimwe tubonye abakiriya bacu baratubwira ati kanaka yaranyambuye rugero cyanze kubariza amasezerano ugahita umwandikira ukamubwira uti nguhaye iminsi 5 n'ubu tubahirije amasezerano turakureka akayimara ntabikore ugahita utegura ikirego ukamurega mu rukiko. Iyo ugeze mu rukiko werekana yaba ari wamwandikiye uti murebe yanze ubwumvikane yanze ku executa ku neza bagahita babona ko mutumvikanye bakakomeza process. Tukavuga rero ngo yaba mediation yari kuba ari precondition bayibaza bati yabaye mu buryo mediation igomba gukorwamo mwerekane ko bakwitabye ko mwugize ibyo mwumvikanaho bikaba biri muri iyo report byafasha wenda itegeko rya mediation bizaba bigaragara ko uko bikorwa. Icya kabiri twabonye ko umuroya umwavoka ari umuntu uri important mu gufasha abakiriya mu mediation abagaidinga abagira inama anasobanura za aspect legales bazi muri proposition batanze nimufata umwanya munini ndetse agomba no kuba mediator nawe nuko yenda agira inama mu mukiriya umwe noneho mediator akabagira bose inama niba yimufata umwanya munini rero kandi igihembo abona akaba ari gatoya bizaca intege abantu usange n'uwo ari kubikora neza aravuga ati biramfata umwaka biramfata iki mwakoze.
Jean de la Croix Havugimana, area from 2010. There are some expressions saying, un client bien traité, c'est un client à vie. A client well received is a client whole life. Again, when I was in year 1 of university, I was told by my dean, Karimunda Eme, that you are coming here to learn the law because you think to be rich. Remember, the money is the result of the work done, not the aim the client wanted it to you. A good mediator, as I think, I did psychology, philosophy and logic in university, or we did it. We have to focus on what the client needs. While in the court, a good lawyer says, persuader, argumenter, convaincre. Persuade, argue, and convince. In mediation, we focus on the will of the party, no need to convince, and to turn the way of reasoning of the judge so that he can be on your side. When the hearing is done, the end of pleading, we lawyers, we hug each other so that we excuse for the mistake committed, while clients are enemies. They don't greet each other. And we work in the name of the society. We represent the state of the law. So once we focus on money, we will lose the aim of protecting the sovereignty of the society, since Rwandans are so, the Rwanda is seen in, donc igihugu kigaragara neza iyo ubutabera bukorwa neza. Ikigaragaza ko bukorwa neza nuko abanyarwanda bumvikana. Nibwo tuzagira abanyarwanda bishimye. Amafaranga ari ni result y'akazi kakozwe kuko umwavoka uje mu mwuga avuga ati ngiye gukira agashaka kumera nka Butare umaze imyaka kuva navuka yari avoka, bizamugora kuko hari ihame rivuga ngo le premier ennemi de l'avocat c'est son client. The first enemy of the lawyer is his client. Such expression will be ended with mediation. Thank you.
So, colleagues, do we accept one more question? Because you had initially time. So we are actually, okay, maybe let's agree with Senior Counsel Geoffrey.
The Senior Counsel Kanjira also here asking for an
okay, maybe may I propose, Honorable Chief Justice, you allow, can we take like the first batch of the question, then we take another one? Yeah, thank you, Honorable Chief Justice. Okay, let's hear from the panelists for the first 5 questions from 5 participants, then we shall take another round of questions. So,
before that, you have to translate a little bit for our tourists.
yes.
What has been said in Rwanda, so that we can ask.
Oh, sorry. So I think the questions or contribution from Councillor Hilary was about fees. So fees has been really a very hot issue in this discussion. First of all, she was saying that in the practice, lawyers and their client consider that the exchanges of correspondences between two parties in the dispute, especially in commercial dispute, saying, oh, you have to execute this, I give you the notice for payment, and once the other party does not respond on time, then they file a case in court saying that the amicable settlement has failed, considering that they have exhausted all the means to settle that problem amicably. And now they said, oh, that is maybe kind of mediation that failed. And she said, proposing that that should not be considered as an attempt to mediation that failed, and made the pre-filing mediation mandatory so that the mediation can be done in a proper professional way as we understand. So she's asking whether the pre-filing mediation can be made like compulsory so that the court can register the case. And another thing is that lawyers in mediation should be well remunerated, and it's still the question, the concern that she shared with the Council Veniste Kagabo, even Batonier contributed on that, and I think Council Florida as well. So all the 5 participants that raised the question have already raised the issue of fees. So I would want to hear from the participant to focus on the fees, because it's really a big concern for the lawyers here participants. And Councillor Jean Dodier, I think he also touched the issue of money, but he said it in English. I think you heard, though he tried to translate us in Kinyarwanda. So I think for Florida, the first question on ethics was a contribution. I think, thank you very much. It was a contribution to what the panel has just said. But the issue of fees, I want the panelists to really talk about the issue of fees. Here we are on court annex mediation, and we are also on mediation in general. So I would request, Bruce, do you want to say something on fees?
There's been a lot of good points raised in this conversation and these observations, and a lot to respond to. I particularly like the reminder that we're all lawyers ascribing to the highest ethical standards. I want to begin with that observation. From there, fees is clearly near and dear to everyone's hearts. I'll talk about that in a moment. The question about pre-filing mediation, I support, as you would expect, anything that gets people in conflict to the table and takes away any stigma associated with there being some disadvantage to that. because what we find, and not for the reasons you might think, that I just support everything mediation-oriented, I don't, but because I know from experience that those cases that come to the table with a professional mediator have a significant chance of resolution. I'll give you an example. In our court system, after parties have gone through a trial, whether it's a jury trial or a judge trial, and by definition have gotten a verdict or judgment, meaning there's a winner or loser, then if they choose to, and most do, they have the opportunity to appeal. You would think at that point nobody would have motivation to mediate because you have a winner and a loser. Yet the court has imposed a mandatory mediation process for all cases that are on appeal. And guess what? The vast majority of those cases also resolve successfully in mediation. I think the statistics I last checked were above 60%. And that speaks to the promise of the process itself, even after the parties have gone through a trial and one has been adjudged victorious and the other not so much. So anything that you can do procedurally to get people to the table will not only improve the chances of that particular dispute resolving, but also to help expedite the cultural development of mediation by getting people even more experience. In terms of fees, look, there's, at a macroeconomic level, the cost of conflict is real. And there are studies, not enough of them yet, but there are studies that show how much time is involved in a conflict of a certain sort, how much money is expended on lawyers. But there's also human cost to various companies. It's why one of our training programs was specifically designed for an industry of bankers, but we've done similar programs for insurance industries and construction industry. I spoke to in the Middle East one year about the value proposition of mediation. And so over time, don't lose sight of the fact that your client base will be further educated, and ultimately they too will be demanding mediation because of their own awareness and appreciation for the many benefits that mediation affords. So the question in the short term, from a macro level, the country also wants to be an appropriate, attractive forum for foreign investment. You want to have a judiciary that works. You want to have lawyers that are responsive. You want to have a system of governance that provides real results to foreign investment. Otherwise, they'll go elsewhere, and we see that in different parts of the world. But relating to lawyers' fees and the value proposition of mediation, again, if you as a lawyer can deliver results to your client in real time and in ways that match up to their needs and interests, then you should be appropriately compensated. If, as Councillor Emmanuel suggested, that's simply a question of redrafting your contract with your clients to include mediation, then that should be done. And it should be done at a level that's commensurate with other services that you provide. Mediators in the United States earn more on an hourly basis than most lawyers. So that's a reflection of the value proposition of mediation. Lawyers, too, who can address their clients' needs in real time should be compensated appropriately. And just because the historical system of compensating lawyers doesn't match up specifically with this newly developing culture of mediation is not a reason to resist it. It's a call to try and think again about how to more appropriately compensate lawyers. I'm not sufficiently familiar with how lawyers are compensated in Rwanda to have the precise answer, but I know they're out there. You all are very smart people, and there's other people you can call on to match up the economics of the mediation practice and the economics of the legal practice so that everybody's appropriately compensated. And that's going to happen, and it needs to happen, both by way of getting the major stakeholder group that you all represent involved to embrace mediation, but it also is going to happen because your clients are going to demand it over time. So better to get ahead of that circumstance with your clients than be responding to it when they demand it ultimately. Those are my thoughts.
Thank you very much, Bruce. Maybe Bernadette, there is one question raised by Venuste Kagabo regarding the time that litigation in commercial courts take as compared to sometimes lengthy mediation processes. And that really brings some people thinking about maybe going through litigation in commercial courts would be more like preferred than going through litigation, mediation, and also considering the fees that court and mediation awards to the lawyers. Would you please say something on that? Because on court proceedings and mediation in commercial courts? Thank you.
Thank you, Honorable Chief Justice. On the question of the time spent in mediation, I think from what the discussions we are having with other mediators internationally, Bruce and Chief Justice Emeritus and the Senior Fellow and Inspector Harrison, we are part of a network of pioneer in mediation worldwide, called Weinstein International Foundation is our organization. And we are used to meet as international mediators around the world to discuss issues around the development of mediation in different jurisdictions. And this issue of mediation fees, lawyers' fees in mediation is an issue that is coming always on the table. And but also time in mediation. What I'm learning from those discussions is that time in mediation depends also on the skills of mediators. For example, for Bruce, when we shadow him mediating or other of his colleagues, mediation is done in one way, maximum 3 days. Right? Yeah. One day mediation, we saw him, he comes in the morning, he starts at 10, and at 5 p.m. they conclude. Generally, it's a one-day mediation. So for us, maybe we are spending a lot of time in mediation because we are in a learning process. And I have seen also here in mediation, it's not easy to organize a full-day mediation because people are not yet prepared to do so. But as we are developing our practice, I think so we will learn how to organize our mediation sessions so that they will not take a lot of time. About the issue of mediators' fees, I would like to say that the scale of fees we have in court mediation applies specifically to mediation of litigated cases, of cases filed in the court. If you do mediation before filing or out of court, you are free to apply, to negotiate your own fee. And when we developed this scale of fees, we looked around, we asked also people in our network what is the pricing system they are applying. And we realized that in court mediation, very often in many places, the people are paid a little money because very often it's an opportunity for beginning mediators to practice, to get skills, and later to develop their own private practice where they can charge a negotiated fee. So that is why for now the system, the scale fee is what it is now. And as I said, it's true in India, in Kenya, in Nigeria, court fees, mediation fees are less than fees you can charge if you have your own private practice well developed. So that you have this possibility of applying your private rate if we are mediating out of court. The court system allows us, we are in an infant system, we are developing our mediation system. The court mediation allows us as accredited mediators to practice, because knowledge is not what you are learning in mediation, the Edward Mediation Academy. This is about knowledge. But to get really skills, we need to also to be practicing. So we have also an infant system, the system that is voluntary. When the civil procedure was reviewed in 2018, we needed time to create local capacity. And the system could not be mandatory at a time where we are not trained and prepared. The 5 years we have spent here from 2018, this is the time to create really a system, to create awareness, to share, to build the system. And you know that the ADL policy recommended pre-filing mediation now. As Councillor Hillary said, it's in the process, but we need this period to be able to create court-accredited mediators who will be involved in the pre-filing mediation. So now the next step is to think about how the legislation will be enacted to allow pre-filing mediation, at least for some cases, and court-ordered mediations. This is the time for us really to prepare ourselves through capacity building. Another thing, as the president of the Bar Association said, capacity building is important, because what we learn, if you know the service you are rendering in mediation, you will be able to explain to your client what you are doing with him. And you are around 1,000, more than 1,000 lawyers. Many of them don't know what they are doing in mediation. If they don't know what they do in mediation, they are not able to explain to their clients their role and how they are supporting them. So capacity building is important, and we have an experience with a group of in-house counsel in the banking sector who have completed the course in mediation advocacy skills. When we meet them in mediation, they have a different attitude and a different approach when they come as counsel supporting their client in mediation. And really we are encouraging you to take this course on mediation advocacy. And this is something we can discuss with Bruce and Susan, how really to benefit from this mediation advocacy course they are delivering in other countries. This course on mediation advocacy will help you to understand, or even to share with you confrere, what is your role in mediation. When they understand the role, when they understand what you are doing, it's easy for clients to pay when you can explain the role you are playing in mediation. So,
maybe Senior Counsel Emmanuel, as a mediation practitioner, I think we need to hear from you with regards to the issue of fees in mediation. Yeah, over to you. Thank you.
Thank you very much, Victor. I think with the issue of the fees for lawyers with regard to mediation, I think that is sorted. So we just needed to add that into our engagement letters with the clients. That is going to be resolved. Now, in terms of the fees for lawyers who are mediators, I would first of all say that let us first of all learn before we actually look for fees. Let us first, get to know what mediation is and embrace it. And start to do as many cases as you can. Now, as I think there is somebody who talked about the multiplier effect. We are looking at the fees for mediators for cases that are referred by courts. And when you look at that scale, it is definitely, the fees are very, very low. But I think as lawyers, before you even think about filing a case, I think counsel here mentioned about writing to the other party. But there is when you write to the other party and the response you get from a lawyer representing the other party, you look at it and you get scared on behalf of your client because of the language used, So I think amongst the lawyers, in the interest and being extremely ethical, in the interest of our clients, we can actually even discuss their issues and get to a resolution of appointing a mediator if we cannot amongst ourselves resolve that issue, without necessarily going to court, and then you wait for court to transfer the case to a mediator. So if you agreed as lawyers that, okay, we cannot agree on a solution to our clients, let us appoint a mediator. Let us agree on Victor. We know him, and now you will be referred. Anybody will think about you because you have actually handled a number of cases. You have been seen in practice as a mediator. If at least we are over 1,000 lawyers, but if at least 100 lawyers have come to you for mediation, then that means you have a very big team that can always refer to you because they have appeared before you. Now, at that time, because it will not be referred by court, you definitely make your money. You are not there when they were discussing. They have amongst themselves agreed on you to mediate. Then there you apply your fees. But now, if we are looking at fees before you even get to know, you have not handled at least 3 cases. At least to get to know even the challenges. And get to know that, in fact, I think if I handle a matter and it is resolved, even if I don't get paid, I'm very happy. Because I have done something really good to a case that was very complex. And when it was actually, in actual sense, not. Just because of ego, because of, so many other issues. So I think, as far as I'm concerned, of course, there are a scale of fees that has been established for cases that are referred to mediators. But in terms of private mediations, where parties decide on who is going to be the mediator, then the other scale does not apply. Then you apply your fees, which is also actually the scale of fees for advocates, because we have scale of fees for negotiations, for all those kinds of work we can do outside the court. So I think we can still make our money if you want to. Now, in terms of the pre-filing mediation, I think I liked the idea of the jury, which is a system in the US, where people go before a jury and then a decision is taken, and before a case is admitted on appeal, then they have to go through mediation. The cases I have handled in mediation that have come as far as the Supreme Court, parties were actually less severe, because they have gone through all the levels of the court system One has lost at this level, another one has won another level. So it has been back and forth. So nobody can say, I have a good case to pursue, so I want to go to court. And you find in most cases, cases that have gone to that level, people are actually ready to negotiate and agree, than cases that have just been filed in the commercial court and they are referred to a mediator. You find that everybody feels that it has a good case. So they are very adamant in terms of, you know, the mediation process. So I would think that if we can get the pre-filing kind of requirement, then that would be at a certain level when people have appeared before the judge, a decision is being rendered, though you have won, you don't know whether you're going to win on the next level. Now, at that time, if there can be that requirement for pre-filing on the appeal level, then the parties are likely to be forthcoming in terms of ensuring that the issues they have are actually mediated. Finally, I think as you grow in a profession, you see so much, and you appreciate whatever happens. Of course, when you tell a young lawyer who has just joined to go into mediation without coming out in court and trying to be combative and try to use all those tactics, then he feels that, no, but am I a practitioner? Yeah? Now, of course, you'll find that in most cases, in cases where you have senior lawyers, mediation is going to be very easy. Everybody will want to participate because most of these senior lawyers have handled so many cases in courts and they have lots of experience. So mediation, because it is not confrontational, you're discussing, and because of their seniority, it becomes very easy to ultimately get to a final solution. So I would urge, even in terms of the programs on training with regard to mediation, the good thing now we have law firms. And in these law firms, we have very senior lawyers. So I would think that if we would have these senior lawyers actually undergo this training, then that knowledge they have got is going to be, you know, shared with their young lawyers or the lawyers in their respective law firms. To an extent that the young lawyer will not feel that if you go to mediation, then you are losing out in practice. So that at least everybody now gets on board. But I think if you started with the seniors, then it will easily, the message will comfortably go to the young lawyers. Thank you very much.
Honorable Chief Justice.
Yeah, thank you, moderator. I am mindful of the time because you see it is 10 minutes to 1, and according to our agenda, we are somehow behind the time. But I'd like really to take the floor to comment the speakers, but also all the colleagues in the audience who contributed by their questions, but also by their comments. The reason why I am saying that is, I may say I am now a satisfied man, really. Why I am saying that? I'm saying that as Bernadette rightly pointed out, you know, and maybe I am speaking for the Chief Justice Emeritus, we started the process, you know, some times ago, without knowing whether people will embrace it. You know, seeing people discussing, having such a rich discussion around mediation is very satisfactory. I'm sure Mr. Edward, who have seen many things, many mediation process across the world, he may say that we are on the right path, really, as far as the mediation process is concerned. So let no one say, especially among the distinguished participants, think that the mediation process that we are promoting is meant to make them poor. No, it is not. Don't think that you will be poor and poorer as far as you are practicing mediation. It is the other way around. So we want you to embrace mediation because, as I can't speak for Mr. Edward, as he was eloquently pointed out, that is something which is appealing worldwide, and we have not really, we don't want to be left out as far as the process is concerned. We don't want to be left out. So let us embark on this process. And of course, we have a long way to go as far as capacity building is concerned. That is true for the judiciary. That is true for all stakeholders, also for the Bar Association. So we'll continue, and we are very lucky that we have very friend of us, especially the Edward Mediation Academy. If you see the kind of training that they are providing us, it is nowhere compared to the kind of fees that they may ask or the time that they are spending. It is a matter of friendship, really, as far as the contribution that they are giving us in order to build our mediation landscape. So capacity building is key, and we will continue to make sure that people are being judged, being the Bar Association, member of the Bar Association will continue, and other stakeholders to continue. Again, as far as the kind of mediation we are having, mandatory, voluntary, the government has stepped up and came up with an year policy. And as the Chief Justice Emeritus pointed out, there are some recommendations, pre-filing. So we will be having, I'm sure that the legislation which is being enacted, which will be enacted shortly, will have some more aspect of mandatory mediation. I'm sure we will have some mandatory mediation in our legal system. So this is, of course, the practice of mediation and some problem that we have been raising. I was saying that I am very pleased with the kind of questions that has been asked by participants, especially with regard to strengthening the ethics and professionalism, because it is a matter of trust. Here, it is more and more a matter of trust. Of course, the justice system is built around trust, but more, even for mediation, it is about trust. So let us strengthen our ethics, and let us strengthen our professionalism as far as mediation, but other dispute resolution mechanisms are concerned. Don't be concerned really that much about the initial scale of fees that we have set up. At least we have started, and we are discussing even the matter. And for the judiciary, of course, we are very happy that we have an advisory committee. So this is also a very important institution which is helping us. And guess what? Helping us, generously, because we are not paying them. Sometimes I am really, concerned when they are exposing their fees, why we don't have, the budget for it. But they are continue to support us because they know they are supporting a bigger case than what we are thinking about, what we are taking as a mediator or the member of the advisory committee. So I think we are on the right path as far as, even if I have put the question to Mr. Edward, I think we are on the right path as far as really building our mediation system is concerned. We have some issues that have been raised, and I am sure the mediation advisory committee, which initiated this session, will be also looking into it, and the judiciary will continue to look into it. Let's, as Mr. Edward put it, let us think on a macro economic level. Let us put us on a macroeconomic level. The multiplying effect that the president of the Bar Association talked about, that is something. Of course, it is very appealing to me as someone who used to work in the private sector, even the central bank. I can see how this kind of dispute resolution mechanism can have an impact on the, on the macro economic aspect. And so I will stop here by saying, you colleagues in the audience, don't think that really mediation will make you poor. No, don't think about it. Because some people, young lawyers, maybe they are not no longer as lawyers. I saw many senior counsel here, so you know what I am talking about. Even young lawyers have not to think that the mediation practice will make them poor. No, but it is very important that they are convinced that what we are trying to do is to build what is said nowadays a multi-pronged approach as far as dispute resolution mechanism concerned. So this multi-pronged approach is what is the trend nowadays. So you will not be thinking, oh yeah, you will be mastering litigation, like, and others say, okay, I will be a good arbitrator. And others say, okay, I will meet myself. You have to have this holistic approach as far as, we are not even talking about dispute resolution. We are talking about dispute management as far as some aspects are concerned. So don't be limited to yourself. Let us learn and learn and learn and strengthen our capacity building. Thank you.
Thank you, Honorable Justice, for your kind contribution to this discussion. And as far as protocols, respect of protocols are concerned, I'm wondering whether there is any room to open for other questions. And
let me maybe apologize to the learned colleagues that wanted to ask questions. But as you can see from the agenda from our program, you will see that we have many, another session, for example, from theory to practice. And I am sure we'll be hearing more and more about these aspects and in a real practice manner. So can we agree that as we are approaching, we are at 1 p.m. As we are at 1 p.m., can we agree that we can adjourn and go for lunch, and then reserve some questions for in the session of this afternoon. Otherwise, we can, for a proper management of our time, I would suggest not to dictate. I would suggest that we can adjourn, and then when we will be discussing, for example, I have seen, for example, Senior Counsel Ukanyira, who went to put a question. When we will be in the lunch time, he may approach, for example, one or another for the question, but also can raise it in the afternoon. Can we agree on that without dictating?
Thank you very much, Honorable Chief Justice, for your guidance, and thank you for the panelists, Mr. Bruce Edwards, Senior Counsel Emmanuel, Madame Bernadette, thank you very much for your contribution. And thank you very much, the audience, your attention, your contribution. It's really, really very, very important for the audience here to hear from you. I know that this kind of proactiveness of participants really show that the better is brighter of mediation, as the Honorable Chief Justice said, and the President of the Bar Association, if the two authorities here like speak the same language of building this culture and constructing, it's really promising. So thank you very much. I hand over the mic to the MC.
Thank you very much. Definitely give me a round of applause as the panelists go back to their seats. Give them a round of a big applause. They did a very good job, and thank you very much. And we are breaking off at this juncture. My Lord the Chief Justice, if you allow, we'll end here and we'll return at around 2:30 because we are behind our schedule and commence the afternoon program. Thank you so much. See you. Lunch is going to be served downstairs.
Experiential. And this is the first step toward experiencing a couple selected moments in mediation advocacy. Let me share with you what we're going to do over the next 45 minutes or so, and it's going to include your participation as well. But first and foremost, thank you to our volunteers who have just been conscripted over the lunch hour to try and help us demonstrate the mediation advocacy moment. As you can see from what I wrote on the board, hopefully, there's going to be 3 different segments of this demonstration. And the first segment you're going to observe is client preparation. What does a mediation advocate do in his or her law firm to bring a client in and try and prepare them for the mediation process? What kind of things should be discussed? What kind of conversation are they being prepared for? And you can assume there's been prior conversations with this client. You know the facts of the case. You have signed a client contract. This is simply the exercise the day before the mediation where you wanted that opportunity for your client to come in and spend a few minutes getting grounded in what the mediation process is and what he or she can expect the next day when they arrive at the mediator's office, which in this case will be me. That's going to be the first demonstration, and there's going to be 2 parts to it. I'm going to ask one of the lawyers and his or her client to wait outside while the other does a demonstration, and then we'll switch places. So you'll actually get to see 2 separate short examples of that client preparation. During this time, I'd like you to be taking notes yourself about things that you saw that worked for you, things that you would like to add to those client conversations and preparation if you were sitting in this chair. So when we engage in a conversation a little later this afternoon, we can develop a broader range of discussion points. After we do that, and before we have a group discussion generally, we'll move right into a joint session. And that'll be the moment where these folks have been ushered into my office and come into a large conference room. You'll see me begin to open the process with them by talking about the mediation process generally, and I'll be asking them questions. They'll be able to make a presentation informally, answering questions. I'm going to try and ask questions of the clients just generally. I just want everybody who has not experienced firsthand what a mediation looks like and feels like to get a closer look at what the process is. And again, during this period of time, I'd like you to write down notes to yourself on what you saw the lawyers doing as mediation advocates, things that you thought would be productive for them, things you might do a little differently. That's fine. We'll engage that conversation a little bit later. And finally, after we go through a part of the joint exercise, I will excuse one of the lawyers and his or her client, and then I will engage the other lawyer and client in what we call a private session or a caucus. But the type of mediation that we often use in the commercial setting is a mix of a joint session, which you'll see, and then some breakout conversations where I, as the mediator, get a chance to explore more in depth what people think about their case, and the lawyer, in turn, has an opportunity to talk with me in front of his or her client privately and out of the presence of the other side. So you'll get a feel for how that part of the process looks as well. And then, again, keeping notes for yourself, think about how that private caucus looks and how you as an advocate can best make use of that caucus to your client's advantage. Once we go through those 3 steps, then we'll open it up to a broader conversation, and we'll hear from everybody, including our participants, about what they saw, what they liked, what worked, what you guys think as mediation advocates might be an appropriate role for you, and I'll lead the conversation so we make sure we have plenty of takeaway points from that. But generally speaking, is that understandable? People understand what you're about to see? Let's do this then. Florida, why don't I ask you and Anna, your client, to step out for just a moment, and I'll come get you as soon as these folks are finished and we're ready for you to switch places. So again, this is going to be the client preparation moment. This is to assume counsel has brought in his client. We're calling her Michelle, and Michelle has come in to speak with the lawyer in preparation for the mediation at his invitation. Okay? So feel free to have microphones close enough to you so people can hear. And this obviously would be a private meeting with just the 2 of them, although I'll be off in the background here listening to their discussion for later purposes, but otherwise it would be a private conversation. So as soon as Anna takes her pen and paper, we'll proceed. Thank you. Go ahead and hold the microphones up so everybody in the back can hear you guys talking.
Michelle, you are most welcome to Ethos Attorneys and Consultants. As I told you, Geoffrey Mwine, we talked over the phone, we discussed about your case, and I got some bit of facts about it. But as you are here, you understand, coming to the law firm, the first thing to do for sure is about the mandate, the engagement, the contract about this case. Your case, I got information about it, and I'm still reading it, but I feel I should charge you, and then after agreeing the contract, you shall bring proof of payment tomorrow, and then we shall discuss the details the way I feel and share it with you, as we had agreed that it should be in a mediation. If that is okay for you, we can go on and discuss about the fees. Is it okay?
Yes, it's okay.
Right, thank you. Now, I'm happy that you got clearly about the discussion we have over the phone from the laws that we have as lawyers in this country. We have the legal fees, so I consider to charge you 1 million. Is it okay for you?
It's okay. I will pay it.
So you would have to pay the advance, and you bring me proof of payment on our account, and then you shall find me with proper details of this case. And then I will tell you the procedures that we shall go through, because we intend to take this matter to the mediator, as we agreed over the phone yesterday, right?
Yeah, okay.
Thank you. I can see now you have understood the case as we discussed over it. So now, will you be able to have paid by tomorrow, 10 o'clock?
This is the receipt of the payment.
So you have done it electronically, and you've certified that you paid. Basically, I think I am preparing the remaining part of your case.
Okay.
So we meet tomorrow for further clarifications about the mediation processes and how we are going to go about it if we meet the mediator. So
Okay.
I think we can break up today.
Okay.
While preparing yourself tomorrow, so that we discuss about mediation processes, and then we shall agree the date that we shall meet the mediator, right?
Okay, it's okay for me.
See you tomorrow.
Please proceed. I'm just an observer.
Good morning, Anna. Good morning. I hope you had a lovely, restful weekend. Thank you for coming in so that we prepare for meeting with the mediator tomorrow. I just wanted to give you a brief about expectations for tomorrow. I'm not quite sure how much you know about mediation proceedings. Or should I just give you
about it?
You have not a lot of understanding?
No.
Okay. So I'm sure you have had or have had occasion to actually interact in a court proceeding. Mediation is a completely different environment. It is an environment where you have a neutral person trying to assist both parties come to an understanding. The decision comes out of two parties coming to an understanding. The neutral mediator is simply there to assist both of you come to an understanding.
Okay.
The reason why I think
It's
this
good.
is...
I have trust in you, and my expectation is that you'll make it.
So
as long as I get my rights, because I'm rest assured that I have a good case, and I must get what I deserve, surely.
So mediation being as a system of ADR is actually very good for this particular matter that you have against your brother. It will help you keep your relationship with your brother because it's not very confrontational. Okay. I don't want you to come towards mediation thinking that you have to win at all costs. It is a process where you will be listened to. You'll give your version of what you need, your expectations, and the other side also does the same. But I can already see that you're very, very concerned about a breakdown in your family relationship.
Okay.
So this process will allow you to actually perhaps save some of what is already broken in your family in this regard. But as counsel, I am going to assist you in this process and to make sure that your needs and the best solution that you would want to get out of this are taken into account. Okay. Do you have any questions so far about the process?
No, my worry was that our family is tearing up, so I would be interested to see our family coming together again, and everything that could help us come together, I would very much appreciate that. Okay.
Is there, for example, anything that you would not want to compromise in this process?
Of course, with my shares, I will not compromise. With my equal portion, I will not compromise. I'm rest assured that I'm getting what I invested, and I think that my returns should not be reduced at any cost. If at all the situation would remain as it was, but then I would be interested if we really remain together and we don't, we at least iron out the dispute that is rising up.
Okay, as a final note, perhaps this may go without saying, but I urge you at all costs to remain respectful, okay, to not lose your temper. It is very evident that your brother has been provocative on certain occasions, so I urge you to remain calm throughout the entire process.
Would you really assure me that this mediation will work out? Because at some time my husband tried to contact him, and he wasn't friendly. He just threatened to go file a case against our family, accusing us of some criminal actions. And I'd really have fear that we might be wasting our time. How assured are you, or how will you assure me that this mediation will work out to some extent?
So I can't assure you 100% that this is going to work. What I can assure you about is that we have a mediator who is highly qualified, highly experienced, but as you know, it takes two to get to a compromise. I know on your side that you are very ready for this and you understand the reasons why you're going into mediation. I cannot speak for the other side, but I believe this process has to be seen through. No matter what the result is, it will not be in vain.
I understand, and I really appreciate the fact that we are going to unite. But then I have fear that the other party would think that I'm just going for mediation because I'm threatened that maybe he's going to accuse me of those fraud actions. But I want them to understand that it's not because I'm fearing of those criminal sanctions they are just accusing me, but for them to understand that I care about the family remaining together. And if they could really understand that, and maybe we are successful with mediation, I would really appreciate you. And I have trust in you, my counsel. Thank you very much.
Thank you for that. But you'll also have an opportunity to express your opinions, to express what you want during the mediation process, and you can clearly, speak to that during the process so that the other party is very much aware about what your motivation is.
Okay, that would be great.
Thank you. This has been productive. Thank you.
Thank you.
Thank you both. Why don't you wait outside? Keep them outside with you while I speak to the group for a minute, and then I'll come get all four of you. Okay, you've seen two different approaches to counseling your client in preparation for mediation. Why don't you take just 2 or 3 minutes and write down notes to yourself about things that you saw that worked, things that you liked, things that you might have done differently, things that you didn't see in those conversations that maybe you'd like to see if you were doing it yourself. So just take a moment and think about that, what you've seen, and write down some thoughts, because I want it to be fresh in your mind when we continue the exercise, the demonstration, and you have a chance to think back on this. You'll have some notes. So take just a minute. See here. You want to do another? We'll do one more session. Okay, we're all learning as we go. So council wants to do one more demonstration of a client preparation session. So we will engage him and learn perhaps even more. Okay. But, okay. You guys stay out for just 1 minute, and I think I understand what he's doing. Give me 1 second.
Yeah. Yeah, most welcome. Michelle?
You see.
How are you? You okay?
Yeah.
As we discussed yesterday, I told you that today's session is to prepare you. To prepare you for the mediation. You know, I read your case.
Okay.
Michelle, you are the firstborn. You pursued tourism. You know, the company Yellowstone is a family company, is a family business. So we opted for mediation on consideration of so many factors, which I believe may be important for you rather than going to court. So one of the most compelling factor inside my heart was to maintain the unity of your family. This is a family business, and the dispute is rising from you against your sister Anna and the husband Jeff. Do you think for sure you should be in that open court against your brother-in-law and your sister? Why don't you consider some other things, drop some other claims, and take up others? Why do you consider taking them to court? Did you think otherwise last night? Because I told you, I called you over the phone, I told you about these things. Did you think otherwise about it? So we should go for arbitral mediation, right? Tell me.
I think if my sister, Anna, is a really member of our family, she will not accept her husband to divide our family. They became the majority shareholders,
yes,
and they started give us less money than before. My parents and I, we were on the head, yes, of this family business. Okay. So I think my sister divided this family, and we don't have to resolve this problem like a family. Yeah.
Yes. You have a very good reason. You need to remain in the family. You are against somebody who tried to divide your family. And that's the reason why we should go for mediation. I hope you are supporting it.
Well, you are my lawyer, and I think maybe what you are saying is for my interest, yes, I think.
Sure.
So I'm sure that I will follow your advice.
Good. You will follow our advice. Thank you so much. I have at least 3 issues that really should convince you why we should go for mediation. And one, I have talked about it. Unity of your family is important for you, and for Anna and the husband, and for your parents. That is 1. 2, the sustainability of the family business. If you go into courts, that business will collapse. They will divide it. So you need to consider that. And even if you are making some claims, please make some claims considering the sustainability of that business, because it is supporting your family. And another important one is that you need to remain in good relationship with your brother-in-law and your sister. So those are issues that should really be in the back of your mind when you are making some claims in front of the mediator. And another thing you need to know, Michelle, when you mediate in front of the mediator will not be dictating things on you. The mediator will be facilitating you. So it's upon you and your sister Anne and your brother Jeff, to discuss issues that you really need to get out of this. That will bring out issues, differences, but maintain the unity of the family and the sustainability of the business. Right?
Okay.
So when we reach there, please always have that in the back of your mind.
I will.
So be prepared to drop some claims and take up some claims. So for us as your lawyer, myself like your lawyer, I will be, advising you whenever you need my advice, but the leading part is you. The things you would be discussing with your sister and your brother-in-law. But I would be coming in issues of law or anything to facilitate you to put things right and write out some commitments that will come out and you will sign them, right?
Okay.
Thank you. So we shall listen, we shall wait for the mediator to call us, and I will inform you immediately as he calls us, and we shall come to meet him.
Okay.
Thank you, Michelle. Nice day.
Please go outside. I'll come get you in just a moment. Thank you both. As you can see, the more you do this, the better you get. Let's go ahead and write down any thoughts for a moment, and then I'm going to bring them in, all four of them, and we're going to start the mediation process. So go ahead and take just a minute to make your last note to yourself. Okay, I will bring them in. Okay, please come in, all four of you. Good morning, everyone. I had the chance to greet you out in the waiting room. I appreciate you waiting for me these last few minutes, and look forward to welcoming you into this process we call mediation. Anna, nice to meet you. Nice to see you here. Michelle, thank you for coming in as well. Let me take a moment and commend you both just for your willingness to participate in this process. I know you're involved in a court action, litigation. We'll describe that process in just a moment, but this is a little bit different today. And what we're going to try and do today is talk with you both about seeing if we can find a resolution that makes sense for both of you. And I'll start by saying the obvious. Cases that involve family disputes are some of the more challenging disputes to resolve, because I know there's a lot of history here involved in this. And we're going to spend whatever time we need to today listening to you, trying to understand how this got to this point, and ultimately to try and see if there is a solution. It does differ from the court aspect in a couple different ways. Predominantly, it differs because while you're both well represented by counsel, and I've had the privilege of working with your lawyers before, ultimately, with their good guidance, the decision of what to do today is up to you. And that's largely how it differs from the court proceeding. Because if we're not able to find resolution in mediation, you'll continue on the path toward the courthouse. And ultimately, the judge will tell one or both of you what you need to do. And that's why one of the reasons this process is to be preferred. So I just want to, I know your lawyers well enough to know they've informed you of this, but just to make sure you hear it from me, let me just take a moment to explain the process. First, I don't represent either of you. I'm not your lawyer, you have capable counsel. I'm a mediator. I do this every day, and I do this in a variety of different kinds of disputes. My job is to help see if I can keep the conversation going to explore different settlement options. And at the end of the day, put you in a position where you're able to make informed, smart choices for yourself. Yes, your lawyers will give you legal guidance in that, but ultimately my hope is that you're in a position to make that decision yourself. And as I've said already, we'll take however much time it requires to get to that moment. I don't know precisely how long this will take. I'll tell you this, in my experience, the longer we're together, the better chance we have to succeed. So be patient. Obviously, we could be here all day, and I know with your lawyer's consent, everybody's agreed to come here for the day. But it takes a while, so be patient with me, and we'll work through it, and we'll try and get to that point. We're bringing in lunch. We keep working through the day, so we'll make this as comfortable for people as possible. If at any point you need to take a break, get up, walk around, leave the room, that's fine. There's no formalities to what we're doing. Do what suits yourself and makes you most comfortable. And if you want to just take a break and speak to your lawyer, all of that's fine too. So that's kind of it for the process. We're going to start in this session initially, and I'm going to hear from your lawyers. I'd like to hear from each of you a little bit as well. And we're going to follow that group conversation with some private conversations where I get to meet with you, Michelle, separately with your counsel, and then with you, Anna, with your counsel as well. So we'll have a chance to talk privately. So if there's anything that you feel more comfortable sharing with me in private, just hold on to that thought for now. We'll get to that moment in the mediation. I guess lastly, I'll say this. Nobody can guarantee an outcome in this process, but I will say, having done this for as long as I have, that it's a process that works. It requires a lot of energy and a lot of time and effort to put into it. But it works because people are committed to trying to see it work. And the longer you stay committed, the better chance we have of succeeding. So let's do this. Anybody have questions at all about the process itself before we get started in conversations? Not yet. Again, feel free at any point throughout the day to ask me questions or comment on how we can improve the process if there are things that don't meet your needs but you want to try and do differently. That's what we're here to try and accommodate. Let's do this. Michelle is the person who brought the lawsuit, so just is probably the easiest place to start with you, Counselor, in terms of your understanding of your client's position. Just conversationally, can you share with me a little bit about how we got to this point, how your client got to this point to bring a lawsuit against family members, and kind of what you view as the strengths of her position?
Thank you, Mediator. But as we are here, as counsels, we normally discuss with our clients, and from what we agreed that he will speak first and tell you why he filed a case against Anna and Jeff, and then thereafter I will supplement if necessary. But that's what we agreed, so I can give her the microphone to.
That would be just fine. Please.
Yes, thank you.
So, Michelle, I know this process is probably a little new to you, and that's understandable. But if you would just explain a little bit about how we got to this point in time. I'm not looking for legalese. I'm not looking for the law. I'm just kind of looking for factually how you got to this point where you felt that it was necessary to then sue the rest of your family in this business dispute.
My parents, Felix and Maggie, they have a family business, and my sister Anna and I, we are members of this family business. My parents struggled to make the business grow, and it was not easy for us. Several years ago, my sister met a man called Jeff, and they got married. Today, they are the majority shareholders of our company. Before they became shareholders, everything was okay. It was like every family, no problem. every member of the family was receiving the interest like normally. But since my brother-in-law and my sister, Anna, they are majority shareholders, there is a problem. My parents and I, we are poor now. And my sister, she knows that problem, but she don't care. So, today, my lawyers advised me to come in mediation. While before, I filed a lawsuit. So, maybe it's a chance to repair our family, maybe. So I'm here today to try this, to try to resolve the problem. So I hope we will resolve it. So.
Thank you, Michelle. I appreciate, again, not just you being here, but you being willing to share that with me directly. We'll have a chance to talk more about some of this privately, but for now, that's a good start, so thank you for sharing that. Let me hear a little bit from your sister and her counsel, and then if there are other thoughts that occur to you, we can talk again. Give me a minute. Appreciate you both listening carefully to that, Florida. I know you've done this many times now and represented clients in difficult circumstances. You want to speak for Anna and her husband, Jeff. Tell me a little bit about how they perceive this potential litigation, and I may have some questions for you along the way.
Thank you. Perhaps it's better that in the interest of fairness, that my client Anna also speaks to herself, for herself, because sometimes the attachment that comes out is on the emotional side. But just to give a small summary before she speaks, my client has done the best that she can under the circumstances for the family business. There has not been any kind of underhanded behavior. The fact that her husband and herself are now majority shareholders in the company is just a function of the expansion. And it is my belief that the situation in which Michelle and the parents find themselves right now is just simply a function of a short-term problem that is going to be resolved once production and the profitability of the expansion are realized. But let's hear from Anna. Thank you.
Great. Thank you. Please, Anna.
Thank you, mediator. Much have been said by my lawyer, but the dispute started all along after my husband became a shareholder. Michelle is she a sister or a brother? She's my sister.
Yes.
And we've been good friends. And our parents gave us an equal share of the of shareholding in our company, and we've been doing good. But issues came up when the company started not making profits. And as per the requirement of the government of Rwanda, we are requested to develop the company and to register the company by fulfilling some of the conditions. Amongst the conditions that we are required to fulfill were to raise the capital of the company, but we had no money at the time. Together with my husband, we secured a loan from the bank, and we mortgaged our house. Of course, the loan was injected in the company, and the capital increased. But that portion of the capital that came into the company was my share, was the share of my family. That's why we had to include my husband as a shareholder. Of course, when you see both of us, you find we are majority shareholders, but still we have an equal share in the company. The problem I have is that Mike, not our parents. Our parents have an understanding, but Michelle, for him, he's seeing the dividends for Jeff, for my husband, and myself, and summing them up to think that we are getting a lion's share of the company. But for sure, the share is equal and proportional to the percentage of the shareholding. Another issue I have with Michelle is that for her, I still have in my mind that this is Michael. For her, she still has that understanding that it's Jeff who is coming to grab the family business. But for sure, today, I would assure her that Jeff is getting her portion, his portion, and I'm getting my portion in a proportional way. And I'm worried with Michelle because she has gone a little far and started manipulating things all over. I've just had an information that he filed a fraud case accusing me of some fraud actions, and I'm very much worried that this can cause problems not only to my family but also to the company. And I just want to warn her that she should be more careful, because we might lose everything, but she would also be answerable for all the accusations she's plotting against me. A mediator, it's good that you are coming up to unite our family. Yes, I agree, but I'll not compromise with my reputation, with my family reputation, and with all those criminal plots that they are fighting against our family. I hope you will assist us to have them ironed out, and I hope everything will be successful. But I want really, she's here to get that understanding that my family, my husband, is a shareholder who's getting what he deserves. We are not thieves. We are not here to have the company fail. And we think our family should be reunited, but let her not keep on tarnishing our names, the family reputation, and let him not be jealous of our only daughter that we have, that have been excelling and who have been enjoying her rights due to the efforts of the parents, because this company have flourished just because of the injections of the family money, and we really deserve what we are getting out of the company. Thank you.
Thank you, Anna. First of all, I appreciate the fact that you're both willing to listen to each other. That's a great starting point. I also hear common themes that run through both of your conversations, themes like wanting to see the business succeed, themes like wanting to preserve the family relationships. Obviously, there are disagreements about what is fair allocation of the company resources, and I do understand that conversation difference. But for now, I think what I would like to do is ask if there's anything more that you would like to say, and then we'll go from there.
Thank you, Mediator, and I appreciate your effort bringing together this family of Felix and Maji. And though we are lawyers, we understand the importance of the family, and for them sitting together on this table really demonstrates their goodwill to maintain the family together. So I think this is a good starting point, and I believe that where there is a will, there is a way. Thank you, Anna. Thank you for being here. I just need to express some issues or give out some issues which I got from my client. After sitting with my client, she told me the background of their family, the struggle they went through while they were still in Congo, and after coming back to Rwanda, the way they organized the starting of this company, Yellowstone. So it is on that background that really affected my client, that she went for tourism, but at the same time they saw tourism together with mining company to set up the family and break that yoke of poverty in their family, and that they were doing good, that things changed after the coming in of your husband, and that they had really explained the information clearly to him before joining the company. So to my client, you shouldn't consider taking the dividends in proportion to your shares, that you should bring down the dividends and fairly share them in the family, at least for them to have a decent life of living from the family business. That's her claim. So it is as if that you ignored the discussion and the background history of your family, and you went back to sit back with your husband, and you forgot your sisters and your parents. And that's her major claim. If you could consider that, then we could be making a step. Thank you.
Thank you. Florida?
Thank you, Mediator. I just want to highlight two things that perhaps the other our friends, Michelle and her counsel may not be considering. The first is that Jeff is not a stranger. Jeff is Anna's husband. Jeff is the father of Michelle's niece. Jeff is part of this family. Let us not look at Jeff as an outsider who has come to disrupt a family unit. He is, for all intents and purposes, for better or worse, part of this family. The second thing that I would like to highlight is that Jeff and Anna actually took out a loan to expand a business that in the long run is going to benefit everybody in this family. Anna and Jeff are actually using part of the dividends they're receiving to actually pay the loan. Not everything that is coming to them as part of their shared dividends is actually money they are pocketing. Also, let us not look at the money that is being paid out as dividends as the only source of income for Anna and Jeff. Let us not look at the lifestyle that they are living, the schools where the children are going, the cars they are buying, and think all of that is being paid out of the dividends. So Anna is the only one who's actually in the mining, running the business, while Jeff has a completely different job, and the family has other investments. And those are just some of the things that I would like to highlight as we look at the problem and the emotions around this family matter. Let us look at the bigger picture of the fact that this is a family unit of which Jeff is part and parcel, and let us not look at him as a stranger who has come to take what lawfully belongs to the family. Thank you.
Thank you. Let me make a suggestion. I think we've had a good start at understanding the issues. It won't be our last time necessarily to have a chance to talk directly. We'll look for those chances throughout the day. But why don't you give me a couple minutes to talk with each side privately, just to advance the conversation. And if you're okay, Anna, let me start with your sister, Michelle, and her counsel in Florida. If I could just ask you to wait down the hall in the waiting room, I'll come get you momentarily. Give us a few minutes, though, to continue the conversation. Okay. Okay if I ask Michelle a question directly, Counselor?
Yes.
Did you learn anything new or different from your sister in that conversation?
Yes, I have learned enough. What her lawyer said before step out, I think there was some consideration. I didn't think about while filing my lawsuit. But I think my sister, Anna, as a family matter or as a family, she would have tell me or approach me or our family or our parents to explain everything to us, because she knew that before her husband became a shareholder, our dividend was more than now. And if there is many problem, if they have a loan to pay back to the bank, yeah, she have to explain everything to us, so that today we will not be here if everything was clear before. So I have learned.
Great. How about you, Counselor? Did you learn anything new in listening to the presentations this morning?
Yeah, thank you, Mediator. One thing I've learned it from here, from the information I had from my client. I didn't know that they got the money from the bank. We didn't know. And I think my client didn't know that her sister Anne and the husband got a loan to capitalize or to recapitalize the company. Secondly, it seems there was information gap. Anna did not give the information clearly to the family about that loan and the servicing of the loan. And I have also learned from here that even Jeff had a different business that brings income to their family. And it seems the sister-in-law, Michelle, my client, didn't know that. She knew everything comes from the company, which is a business of the family. And now it kinds of, I'm getting new information which she didn't know and which we didn't know. So probably it will be upon your skills as a mediator to help us in that regard. And also there's still kind of anger in the in the tone and the voice of Anna, seemingly threatening the sister Michelle and doing it in front of the mediator. That means it is still there. So probably I would propose this to you as a mediator to look on how they could calm down and speak as a family in a respectable manner, in a friendly tone. So I have noticed those things. So as she has said, I'm like her. I haven't known all these facts.
Yeah.
Thank you.
So, obviously, I picked up the same level of emotion you did in listening to Anna, and everyone's entitled to feel how they feel when they get accused of things or threatened with lawsuits. I'll talk with her more about that. In terms of the communication issues, though, I did listen carefully to what they were saying, and obviously it sounds like they borrowed money, took out a loan against their house to recapitalize the business. I don't know if you caught it, but did you hear Florida say that this could be a short-term problem, that the money once invested in the company and recapitalized will produce greater dividends for everyone in the future? Did you hear that?
Yeah, I heard that from the lawyer.
Do you?
But I would have loved to hear it from probably Anna or the husband.
I'll try and explore that a bit more as well. Michelle, what has your relationship been like with your sister throughout your adult life? Would you describe yourselves? How would you describe yourselves?
As she said, we are not only sister, we are friends. Mm-hmm. So before we have a good relationship, yeah, we are friends, we are sisters. So.
How do you feel about her husband, Jeff?
I don't like it. Mm-hmm. I don't like him because, yeah, it's true. It's like a stranger. Mm-hmm. Since he's between my sister and me, it's like a stranger, like a thief. Really, that is my feeling. Yeah.
Are you close with their daughter, Kiza?
Yes. Yeah. She's nice. I like her.
And I understand there's been some disruption in the family because of this dispute in terms of people's ability to spend time with each other. That's something you'd like to see changed?
I don't know. For now, I don't know.
Okay. Let's do this. I want to speak to them for just a couple minutes, but I appreciate your willingness to kind of share with me what you have. You've given me some thoughts on questions to ask them, so let me proceed in that fashion. But if I give you guys a break for a few minutes, I'll ask you to wait outside. And would you ask them to come back in, please, when you head out into the hallway? Thank you again. Thank you, Anna. Thank you, Florida, for your patience. You listened to your sister, and you listened to their lawyer in that group presentation. Did you learn anything new or different from what you thought coming in today?
I was actually quite worried that the emotions would take over, considering what has happened a couple of times when she met with my client. But I was pleasantly surprised that the tone is conciliatory. Mm-hmm. So the one thing that I learned is that there is goodwill on both sides, which is something new.
Yes, I had the same sense. How about you? You know your sister better than any of us.
Myself was hot-tempered, but I've been advised by my lawyer to calm down. I hope also my sister was advised to calm down, because I'm worried that she's going around tarnishing my name and our family affairs, and sometimes I get hot-tempered when I think of that. But because I feel this process is unity-centered and is going to unite our family, I'm embracing it, and I have too much expectations in it, that all the disputes will be ironed out, and that perhaps I'll keep having my share, the same percentage I've been having from my shareholding portion. And actually, I've been a managing director of this company, and I'm doing that for free. If they had hired another managing director, they would be paying her or him. But I'm doing that for free. I'm just getting dividends from my shares. So I expected my sister to be really understanding. And as we used to be friends, I expected her to remain friendly. And I'm really disappointed in her, but I have to keep calm, and I expect to have this process go smoothly, and everything works out as we expect.
For whatever it's worth, she wasn't tarnishing you or your reputation in our private conversation. In fact, she described your relationship over time as being one of not just sisters but friends, and certainly expressed her love for your child. And my sense is the willingness to try and see if things can be mended. That said, there were also things that they learned that they hadn't heard before. I don't know to what extent there's communication amongst the shareholders in the family business, but it seems like she was lacking some information, that she was specifically not aware that you and Jeff had taken out a loan and a mortgage to recapitalize the company. Do you know, had that information gone out to other family members, why she wouldn't know that?
I'm not very sure, but I thought she understood everything. But if that's how you found it, then that would be great.
Does she know that you're donating your time to manage the company?
Yes, she knows that.
She knows that.
She knows that. But just because she's jealous, she cannot perceive that. She really sees it in another angle, just because of jealousy. If you could really convince her or persuade her to have that jealous go out of her, then maybe everything could be fine. The problem is jealous.
If I could do that, I would charge more.
She's jealous against my husband. She's jealous of me. She's just because she's not even married.
Did she? Do you think she knew your husband had a different job and an alternate source of income?
She knows everything.
She knows everything. Do you know why she would tell me that this is some new information to her? No idea.
How do you find it?
Flor, you said at one point that you viewed this recapitalization as a short-term issue, that it was going to turn the company around to be more profitable for all shareholders, if I heard you correctly. Tell me more information about that I could share with her, maybe to give her some better promise of the future.
So, in essence, what has happened to this company is that the company has recapitalized, has bought more machines, and that means that in terms of production, the company is having to buy more material to work with the new machines. They're having to put in more money to pay more employees that have had to be brought upon, into the company to use the new machines. We have had to, the company has had to hire consultants to teach the employees how to use these machines, and all of that is capital intensive, which means it's eating into the profits and that are going to be shared among the shareholders. So I view this as a short-term problem until the new machines are capitalized upon and the production is expanded such that profitability is improved. So it is a short-term problem, and I don't believe that Michelle appreciates that. And on the points that my client has expounded upon that Michelle should be aware of, or at least that Anna thinks Michelle is aware of, it's a good thing that she's coming to the point of saying, oh, whether truthfully or not, I didn't have this information. Now that she does, I think we should all take advantage of that to move the conversation forward, to come to an understanding that benefits everybody in the family.
Perfect. Let's pause here, okay? Let me bring them in for just a moment, but thank you both. Give me a second.
Jealous people.
They've left the building.
Oh my God.
Kidding. Back in there.
We shall assume they're trying to get the jealousy out of her.
I think so. She was shaking her upside down last I saw. Yeah. I know you only have a few minutes, so I'll kind of ask you for an observation first, and then you'll need to leave. Oh, you have a little more time? Okay, good. Okay. First of all, can we have a round of applause for our participants here in the demonstration? I thought they did a great job, so thank you. I don't know about the rest of you, but I would like to continue this mediation and help them resolve their issue. It seemed like we were making good progress. But we're going to pause here because I want to talk about what you've seen. And so let's begin with the client preparation moment that you observed. Will you tell people what you were trying to accomplish in your client preparation, what was on your list of things to speak with Michelle about, just so everybody can hear that? After you got past the fee part.
I
I actually decided to consider 2 sessions to meeting my client, prepare my client in 2 sessions. And the first meeting was to, formalize the issues of contract, formalize the issues of, payment and get the proof of payment. And then thereafter, the first actually was a telephone conversation about the case. So after coming, then I had to tell her from the conversation we had, from the telephone we had, I have heard about your case. It was a family case. Now we are going to go into it, but we have to have a contract for that matter. So, and then I actually said, you will go pay, bring proof of payment for mediation process preparation.
Yes, and she paid you promptly.
And then she paid promptly, electronically. And so it's kind of like, wow, she has paid me. She caught me off guard, say, no, I have cleared, I have paid. And then I said, okay, fine, but I still have some issues, some facts to get from your case. So come tomorrow for mediation process preparation. And so that's what we did. So the second meeting actually was coming like our colleagues were telling us, no, we are now going out for joint session. But I insisted, I said, I have to go and request second session with my client because that was our agreement, our verbal agreement. Okay. And that's how I came to tell you to give us another opportunity because that's what I agreed with my client. And so after coming, I put her in that position that a question will kind of come why you filed a legal case against your sister. To prepare her that she should be knowing that she will have to answer such a question as in mediation. And then I had to give her the benefits of going for mediation emanating from a family dispute, and I had to give all those advantages, family unity, expedite the outcome. I think something like remain friendly with the sister. And then I also told her that the mediator will not impose anything on us, but rather being a facilitator, to facilitate the process. And the process comes from them, not from us. For us, we'll be there as lawyers, probably guide them, and probably prepare a settlement agreement, but they are them. And be prepared. I prepared her to consider dropping some claims and take up some others, and that's what is done in mediation. I think this is what I had.
Thank you. Florida, how about you? What did you attempt to do in preparing Anna for the mediation?
So I attempted to do a number of things, but the first one was to simply inform her about what to expect in the process, how it is conducted. The second one is to ensure that she knew her rights would be protected, and that her interests would also be, defended, but in an atmosphere that is not confrontational. The third thing I try to do is to request, because I know what usually happens when it's family matters, people's emotions tend to take the better of them. So I kind of had to counsel my client to make sure that her demeanor and her tone of voice and everything else to be conciliatory and friendly instead of confrontational for her to get the best out of it. So in terms of the first thing about expectations of the process, is especially to make sure that she understood that this process has the best chance of maintaining a family relationship with her sister. I think that's it.
Thank you. I noticed you both, as advocates, came into the joint session and pretty quickly turned the conversation over to your clients, which was extraordinary because it's not all that typical. What was the thought process in doing that from you first, and letting Michelle speak for herself?
I considered that based on the nature of the dispute. Being a family dispute, as my colleague has said, it really carries emotions. And I had prepared her that she will have to give out the basis of her claim, the basis, the reason why she took the matter to court, just in brief. It is what actually we had agreed. In some other cases, we don't normally, lawyers sometimes we may go far and worsen the mediation process, kind of like bring some issues that may raise some other emotions of our clients. So it's better that you build on what they have said and what they have told the mediator, and you also bring it down. Because some of us lawyers, we may go to become a legal, paralegal, kind of, you did this, and you invoke the hidden emotions that may flare up and, make the mediation difficult for you. But it is better you calm it down if you know, although there are some legal grounds, but you let the people talk on the basis of understanding and respecting each other. And they bring out their emotional feelings, and probably you build from there, not you starting, and you stretch things far, and that you make worsen the situation of ADR. And in ADR you need to, conform to your client's views and emotional feelings, and you build on those. That's why actually I insisted for her to start.
Thank you. Good. Florida, how about you? What went into your decision?
I was actually quite surprised that Geoffrey gave the opportunity to his client to speak first, because reading this, it seemed to me that his client was a bit volatile, so it could have gone either way. Mm-hmm. But when it came to me, the reason why I did what I did was a tactical decision on my part, thinking that the client that I thought was going to be volatile instead came in conciliatory, meaning that if I had taken over completely and not given her an opportunity to speak, then she would not have been given an opportunity to also be conciliatory, to start it off on a very good tone. But had I been on the other side, I would have likely been the only one to speak at the beginning without giving my client the opportunity.
So you came in prepared to talk a bit more, but made the strategic decision based on how things started to turn things over to Anna.
Absolutely.
Interesting. Let me hear from the clients for just a moment. I'll start with you, Anna. Did you feel you were prepared sufficiently coming into the process to know what to expect? Is there anything more you would have liked to have heard from Florida? And how did you feel generally about the conversation?
Yes. I wanted to be rest assured that my interests would be catered for. That's why I insisted on giving her my position. Mm-hmm. I wanted also to kind of let her understand that I want to give out a message to the claimant that although I'm going for mediation, it's not because she's having a genuine case against me, but it was just for reasons of having our family reunited. And yes, I was prepared because I was advised always to keep calm. I was like volatile, although the other side would have been more volatile. But all my expectations were met, because however much you could convince me to keep calm, to go for mediation, to go forward, I would always insist on my position and feel like my interests are catered for.
Did you appreciate the opportunity to be involved in the conversation as much as you were?
Yeah, Yeah, I appreciate it. I was like, there are some issues I didn't, I wanted not to go into, because I felt like the lawyer would describe the issues and the factual background more than myself, because for me, I wanted to express my emotions that I'm disappointed with the actions of my sister, of suing me before the court, before the civil court, going for criminal, another criminal suit that she was trying to file against me. And it's like I would leave the real facts of the case to the lawyer to describe. And for me, I wanted just to show the panel that I'm already disappointed. And my sister is acting against Jairus, not that she has gaining case against me.
Let me hear from your sister for a moment, lest we fall back into our roles. Michelle, how about you? Stick with the process for just a moment. Did you feel you were well prepared? Did you feel that you understood the process enough coming in, and how did it make you feel to be included?
When I came to my lawyer office, I didn't want to hear anything. I just want to go to court and finish with this case. But I trust my lawyer. He gave me advantages of mediation and explained everything to me. So I just have confidence, and I said, let's have an open mind, and come, you will see. So when we came here, everything was okay. But now my sister wants to destroy everything. So I'm asking myself, should we continue? Because I think I can continue with my lawsuit if she wants to threaten me. So.
What, turning to, I'm resisting the temptation to go back into the mediation here. The private meeting that we had, did you, what was your impression of the private meeting? Maybe starting with the lawyer's perspective first. Did that give you an opportunity to share things privately and separately?
Yeah, I appreciated your analysis of all your mediating private sessions. And the way you raised questions to us, it enabled us to bring out what we have heard from another party, what has been a surprise to us. We expressed that. And in a jovial mood, you made us to clearly bring it out without probably, kind of like telling us you've done this, you are intending to do this. But the way you asked us, for sure, was a high level of professionalism in mediation, which actually we are copying from you. Probably one time we shall be somewhere in the mid towards yours. It was super professional to get that information in sessions, and I have appreciated as a lawyer the way you asked me, and then I explained the new information I have heard from the other party in front of you. I'm not sure whether it is of importance to go back at them, because we talked about them in private sessions, and they remain private unless you, as a mediator, you want us to bring them out. So that's why I cannot. But we told you what really kind of caught us off guard from the information. We told you we have heard this one from here, and it will remain private until you permit us or you tell us to talk about them.
Thank you. Florida, how about you in the private session? What was your impression? What was your takeaway from that?
So my biggest takeaway was that even with all the counseling I gave to my client, when we came to private meetings, she decided to be super honest and started talking about the jealous stuff and all of that, which I think is always a good thing, because then the mediator understands clearly what is happening in this relationship and what people are thinking. She felt comfortable enough to talk about the things she couldn't in front of her sister,
yes,
which informs the mediation and the mediator, how to handle those issues that would not have come out in the joint sessions.
And for whatever it's worth, despite your best efforts to tell people to tamp down their emotions, I was prepared for a lot more. So not that they needed to go there, but most mediators are trained that if you are displaying emotions, it's to be expected, and we're prepared to address that in a positive way. Let's do this. Let's take a step back from this conversation. Oh, let me ask.
She expressed her, I think.
Yeah, please. Oh,
She expressed her emotions.
Thank you. Do you want to talk for a minute about, Michelle, your emotion?
If you permit her, she would probably express.
Yeah.
I'm starting to wonder what was happening outside when you guys were.
No, beside it from here. There's something which I liked from her when you asked about her brother-in-law.
Yeah.
She expressed her emotions.
I saw that. But I treated that as confidential.
Mm.
I didn't want to drive a deeper wedge between the two sisters.
Okay.
Sometimes judgment is important. Let's do this. Let's open the conversation to others, because I'm interested in the response from all of you who maybe are seeing some of this for the first time. And what I'd like to focus on initially is the client preparation, focusing on the lawyer's role as a mediation advocate. Were there observations that you made? Do you want to comment on anyone, or things that you felt maybe weren't touched on by the lawyers that you would like to see included in a client conversation of your own? This would be the group participation time. I thought they did a good job of getting their clients ready. And in a real case, I suspect they probably would have spent some time talking about their clients' objectives, what they want, what did their clients want out of the mediation process ultimately as they fashioned a conversation for settlement discussions. Thank you. Yes, sir.
Thank you. It's just to ask the role of lawyer in mediation. Is it necessary that the lawyer become active in mediation, as it was in this demonstration? That's my question.
Would you ask it one more time? I just want to make sure I have the question right.
Yes, I say, is it necessary that the lawyer becomes active in mediation?
So what I saw, thank you for the question. This was an interesting mediation from the standpoint that typically the lawyers are more engaged initially. And we talked earlier about the lawyers having a valuable role in mediation. In most instances, I would expect the lawyers to be more of an advocate initially. And I don't say that critically. I actually think it's a higher level of sophistication what these two were able to do, because they had a different mental model. They had a model that recognized this early on as a family dispute, and they were deferring to their clients appropriately to really express their sentiments, and I think resisted the temptation initially to try and talk about the law and about things that maybe have been less consequential and maybe even potentially inflammatory, as was just discussed. So what you saw was a very higher level of mediation advocacy, being prepared but being flexible, being attentive to the emotional needs of the clients, as opposed to just coming in with a script to talk about why we were going to prevail on our theories of fraud or conversion or other legal theories. So to that extent, it was both a little different, but also illustrative of a higher level of mediation advocacy. And it was interesting to me to see that play out. Other questions about the client preparation part of the mediation, things that might otherwise be on your list to consider? And truly, when you begin, I think it is helpful to develop a list, a checklist, if you will. I'm not a huge fan of checklists generally in mediation because we need to be so fluid within the process. But I do think that when you're starting out particularly, and when you have clients coming into your office to prepare them for mediation, there are standard things that you want to make sure you go over with them once your fee arrangement is confirmed. You obviously want to talk to them about the process. You want to talk to them about how confidentiality will be handled. You want to talk to them about what different options there are for their involvement in the process. Is Michelle going to be asked to speak? If so, at what point in the process, and what's she likely to be asked? You want to give her a comfort level so she knows what to expect when a mediator does call on her. And then, as I said already, you want to have some conversation about potential outcomes. And just like a mediator would be expected to ask, you would probably want to ask her, at the end of this process, what do you hope to achieve? And where do you see that playing out at the end of the day? What are some of the concessions you might be willing to make? Let's talk about some creative ideas for maybe going forward and reconfiguring the dividend payout for this business in ways that acknowledge, what we learned. And then preparing your client for the fact that she probably doesn't know everything that she's going to know by this time tomorrow, listening to her sister and the lawyer on the other side. So we have to remain flexible to a degree in anticipation of that new information. That's one of the hallmarks of mediation, one of its values. So these are all things that should be on your checklist. And I've said this many times before, and sometimes to those of you taking courses, but in mediation and mediation skill development, and that includes mediation advocacy skill development, the opportunity to practice these moments, there's no substitute for that. Being able to get into reflective groups, meaning small groups like the tables that you're in, and practicing these moments so you can expand your checklist, practice the language that you would use in talking with a client. All of those are invaluable skills to be developed, but they're only going to be developed through practice. I can sit down and stand up there and write down a checklist for you, and you'll say, great, I've got the checklist, and you'll put it in your file, and you'll say, when my client comes in, I'll have a checklist. But that's just the beginning. You need to be able to engage in a conversation, knowing how those points on the checklist are important and what goes into that part of the conversation. So don't overlook the value of having those conversations with each other in reflective groups. All right, let me ask you a little bit more about the joint session. What did you observe from the lawyer's or the client's perspective that surprised you or that you want to comment on or ask questions about? Not everybody can hear you like I can.
I have a question. I guess it's a comment first for Jeffrey, but Anna, you particularly, I noticed that when you were doing your opening statement, you directed your comments directly to Anna. Anna, how did that make you feel? As opposed to the mediator or the lawyer.
Anna, did you notice that? Did you feel that he was looking at you and speaking to you directly? Were you aware of that? When he was speaking to you in the opening, were you aware that he was looking at you and directing his conversation to you?
I didn't think of that. My attention was always to my sister. And I was like, I wanted to see if my sister is shooting some other words behind the back of the lawyer. And I wanted to understand if really what the lawyer is saying is from the minds of my sister. That's why I insisted on seeing, observing the body language of my sister, other than observing the lawyer.
Florida, did you notice that?
I actually didn't, because the entire tone of the voice was always quite conciliatory and not attacking.
Yeah.
So I think that's why we didn't pay too much attention to what they were doing with their eyes, because the words were very friendly. So.
It's an effective and higher advocacy skill, what he did, which was to keep his voice calm, so that alone would not be objectionable, but directing his comments and his body language and his eye contact directly to Anna, the client, because a lot of lawyers might find that objectionable. A lot of lawyers might call him out for it and say, counsel, you can look at me when you're sharing your thoughts, but please don't direct this to my client. And sometimes you get into those moments, you know, as a mediator, but if you can get away with it, quote unquote, what a great opportunity to be able to address the other side directly. Good comment. Other observations about what went on here?
It seems there is a question Susan asked me.
Oh, I'm sorry.
Part of it has been answered, I think. In such a circumstance, in a mediation, having the nature of such a dispute of a family, as lawyers, you really get in the emotions of your people. And the way I talked to Anna and the council was kind of thanking them, appreciating them, what they have done, that it is actually something that builds the unit of the family, their relationship, and actually, you know, kind of uplift them, you know, to a certain level. I did it deliberately, you know, not, you know, that kind of reconciliatory tongue, showing them that as lawyers, we are just with them, but it is upon them to bring back the relationship of the family and the unit of the family.
I just couldn't believe in you.
That's it. That's it. You could not believe in me, but if I had talked something, let's say, upsetting your mind, I shift your position in regard to what you are going to talk in front of the mediator, and you become either angry or kind of upset, or, you know, and that would kind of like set you so many steps backward. So you have to be extremely careful if you're a lawyer in such a matters.
Yes, and very attentive.
And very attentive.
Yeah. Other observations about the joint session? You had an observation, yes.
Thank you so much. I would like to thank everyone and comment on what has been going on. I am Mutoni Sarah. I would like to know, in the real sense, when it is happening on practical side, it is usually aggressive. None of the parties are willing to come to the consensus. I can take an example of us, the Rwandese. Mostly they even want to fight because they came without knowing this peaceful method of sorting things. Now I'm wondering if they start fighting or if they start being rude and aggressive to each other, and maybe using the tone that is not conciliatory. What do we do? And the other side, I would like to thank the impartiality of the moderator, or I mean the mediator, to the two sides that were going through the session. The two sides, you did not show any side, maybe the winning side and the losing side. You were trying to be so impartial through the two sides, and then how the lawyers were so interactive to their clients, and they looked to be part of the problem. And so it was so good. I liked that. Thank you so much.
Thank you for those observations. I agree with you completely that it was a great example of lawyers including clients in the mediation process. That strikes to the heart of the mediation process. What we're trying to do is to include the clients. To your question about what do you do if clients particularly, although sometimes lawyers, because lawyers are not immune from emotions, I assure you, but when clients start to interact with each other in a way that's not viewed by many as being productive, how do you respond? This is a long conversation, but I'll give you the brief answer. We know from the mediation training that we do that emotions are a natural part of the human condition, that they're to be expected. And oftentimes when we ask people to relay things factually or cognitively that draw up memories, that emotions come back with that cognitive of memory, and therefore people start to get angry again, even though they've been advised not to. And so I expect that. And here's where it gets a little bit tricky. most lawyers, not these two I don't think, but most lawyers are uncomfortable in the presence of high emotion, particularly starting from their clients. And their first response is to try and tamp it down or shut it off entirely and say, please, Michelle, keep this under control. And I think in doing that, they do a bit of a disservice to their clients, because there are emotions that underlie what we're talking about today, honest, sincere emotions that need to be addressed. And until we can get through some of those emotions, we may not be able to get to the ultimate discussions about solutions. So I, for one, am hoping that I'll see some emotion in this conversation. When it does appear, the question is determining what is productive and what is less than productive, all the while looking at the lawyers to gauge their comfort level as well. So as a mediator, I know from experience that sometimes that emotional exchange will not only tell me more about the nature of the dispute than I learned from reading all of the mediation briefs, but it'll be an important first step for the two of them to develop some degree of healing that may be necessary for them moving forward in the negotiation. So I'm attentive to it. I'm inclined to let it play out, probably more than the lawyers are initially, but I'm also cognizant that at some point it can be counterproductive and needs to be managed appropriately. Where you draw that line is really a function of the level of the mediator's own emotional competency. How comfortable am I in the presence of high emotions? And that's something I've had to work on, over the years to try and get more comfortable. The same is true for lawyers. The more you all can get comfortable with your own emotions and appreciate the role of emotions in mediation, the more inclined you're going to be to let that conversation take its natural course. That answers your question. Mm-hmm. Other observations or comments about the process that you've seen so far? Ah, good.
Some attitude from parties. I didn't appreciate the use of some violent words, like jealous, but I expected that as mediator, you correct the audience and you bring them on board or discipline and what's the role of mediator to that?
It is a challenging role, and I try to be very attentive to all of those things that are happening in the moment, I assure you. But that comes from having things get out of control more than once. Okay, other questions or observations that people have, please.
Thank you. Actually, I'm interested in a criminal matter where each one is convincing, want to express each other, especially lawyer. But in mediation, the mood is very interesting. There is no expression but expectation to other side. This is what I appreciated in this scenario. I tried to note something. First of all, here, comparatively to what we are used to, there is no emotion is allowed, but in a hearing or litigation, emotion is not allowed. So in a criminal matter, when you're mitigating, the judge tells you, we are in a court of law, not court of emotion. But here, this is a court of emotion.
So it's interesting that you would observe that. When I first started 35 years ago, I defined mediation fairly simplistically. Mediation was a process that was based on understanding the parties' needs and interests. And secondarily, it was a process that respected people's right of self-determination, meaning that everybody should have the right to participate in making those decisions in conflict that will impact the rest of their lives. Over the years, as we learned a lot more about neurobiology, about different parts of science that impact emotions, I added to that list of characteristics, definitional characteristics, the authentic display of emotions. Because, as I've said already, you can't separate emotions from cognitive thinking. And yet we try, right, for hundreds of years in our court system, out of our court system, at least in the United States, it's all been about the facts and the law. Emotions had no place in the courtroom, basically. When they did arise, the court would take a recess, send somebody out into the hallway to compose themselves, right? So emotions were always devalued, and they had no appropriate role. Yet we know that that is disingenuous at best. It's contrary to the human condition. And so in mediation, we encourage emotions and we give them the opportunity to show themselves in an authentic way. And that is one of the tremendous benefits of mediation, because we know that a part of going from conflict to resolution typically involves some progression of emotions and some level of emotional involvement. So it's a broader conversation than beyond today, other than for you as mediation advocates to appreciate part of what most well-trained mediators are trying to do is make sure that emotions have the authentic opportunity to be displayed in the conversation. In the criminal context, it's interesting. I was just in, where was I? Dubai last week, where we were teaching and talking with judges from Lebanon and other parts of the Middle East who were experimenting using these same mediation techniques in the criminal courts, bringing victims and offenders together for conversations in a way that would materially advance the administration of criminal justice. And so that too showed the opportunity for authentic displays of emotion in the criminal setting. But that's a much newer field for people to apply these mediation skills. Thank you for the question. Okay, I think we're kind of nearing the end of the day. Please.
Maybe my question is purely legal. Maybe I just wanted to know from you, or maybe from the U.S. experience, if all the cases can be mediated, and if yes, I would like to know more about the criminal cases, on how to mediate those criminal cases, because sometimes they involve public order, and some schools of thought have it like there are some criminal actions that shouldn't be mediated or arbitrated, or cases in which we cannot use ADR, but we can only use litigation. From the U.S. experience, how do you make it?
So the first part of your question first, in terms of commercial civil litigation, the vast majority of cases benefit from mediation, can actually be resolved in the mediation process, ranging from business disputes, banking disputes, insurance disputes, large environmental toxic waste sites, large construction projects, personal injury, wrongful death cases from the simplest, smallest type of example up to airplane crashes and mass casualties. All of these kinds of cases are ripe for mediation in the civil context. Again, I said this earlier this morning to everybody, mediation and mediation advocacy is not intended to replace litigation advocacy. Even within those kinds of cases, there are those opportunities for litigation advocacy and ultimately litigation. You heard the Chief Justice, I think it was, or this afternoon, talking about cases where mediation can at least narrow the issues on some matters that go forward to trial. So it's a combination of mediation and litigation advocacy. So don't overlook that opportunity to use a hybrid approach in different kinds of cases that would benefit from it. On the criminal side, so I'll start by saying I'm not an expert in that at all. It's almost not used in the United States much to my experience. It just hasn't found its way into the criminal justice system. I'm not sure why that is yet, other than we haven't spent a lot of time trying to advance the message in the criminal side. They've got a long history of plea negotiation anyway. There is an overlap, and I'll give you an example. I just finished mediating a case in Las Vegas involving several gymnastics studios where a coach had sexually molested young women who were training for the Olympic team. He was prosecuted in the criminal justice system, went to prison, And we were mediating the civil litigation brought by those young women against the chain of studios and the owners of those studios. So there's often an overlap between the criminal and civil justice system when we're mediating. All right, any final questions? Thank you, everybody. Appreciate everybody's good attention. Let me, Harrison, do you want to take the microphone and wrap up from this point? But again, can I get a round of applause for those who did the demonstrations today? I really appreciate their good work.
Thank you very much, and another round of applause to Mr. Bruce for doing this very much. Thank you very much, Mr. Bruce. I think each and every one of us that has come in since morning, we are not going out the same that we came in. So thank you so much, and thank you very much, the participants, also for all the time that you spent from morning up to this time and being very active and interactive in all that you've been throughout this. So we've come to the conclusion, and on our schedule, definitely we only have the wrap-up and the closing session. We have the president of the Rwanda Bar Association with us here, who is going to do the closing remarks. So without further ado, I request probably the rest that are not seated very well to have a seat, and then we're going to close this at the end. So probably we were supposed to be having a break, but we thought it's good that we do the closing, and then after we will have the break, as the coffee break as we go. Thank you so much. At this juncture, I would like to request the president of the Bar Association to use the podium as he closes our day. Thank you so very much.
A good afternoon to everyone. We're not going to take too long because it's been a long day from the time when you're seated. But I want to imagine that you've had a fruitful day, and you've got to learn practical exercise in the afternoon. I have no single doubt that this day is beneficial for the members that have attended this session. And without further ado, since we've taken too long today to make sure that we understand at least the basics in mediation, I want to thank you all for your attention and for having attended since in the morning up to now. And we're going to consider the team that we worked with today as pioneers of mediation in Rwanda Bar Association. Of course, we have a good number of people that were trained in mediation in the previous years, but this time around, with the enactment and the approval of the ADR policy by the government of Rwanda, we're going to be having a good number of sessions to make sure that lawyers get to be familiar with this ADR process, and this will allow us to change the way we used to practice quite a little bit. And I have no single doubt that this is going to be another model of business that is completely different. Litigation as a business for lawyers is not going away, but then mediation and any other form of alternative dispute resolution is another avenue, a new avenue that we should make sure that we explore, and then make sure that we keep on building this culture of educating our clients and letting them know that resolving dispute amicably gives them an opportunity to continue working together, and this improves their life in terms of like not allowing the emotional distress, like for instance of spending 5 years in court, and then at the end of the day you think that you've won, yet in real matters of like for instance the calculation of what you've spent, you've lost. So let me at this point declare this session closed, and I want to thank you, and at this point we can then invite you for the tea break and coffee. For those who can afford to drink coffee in the evening, go and enjoy. Thank you.